Good afternoon. The public interview on candidates for the position of Chief Justice of the Supreme Court is hereby resumed. The following will be interviewed this afternoon: Associate Justice Arturo Di Brion of the Supreme Court, Commissioner Rene V. Sarmiento of the Commission on Elections and Professor San Beda College of Law, and retired Judge Manuel de Jesus Cia Inco of the Regional Trial Court Branch 6, Malolos, Bulacan. We have today with us, retired Judge Manuel Cia Inco. We have with us Justice Arturo Di Brion.
Are you now ready, Justice Brion? Justice Art? Yes. Okay. Any manifestation?
May I present a short statement? I don't have any written text. I just want to clarify at the outset my vision for the court.
Okay.
So that, this can be related to your questions somehow.
Can we limit your opening statement to say 3 minutes?
It will not be more than 3 minutes, Your Honor.
Here you go. Okay, go ahead.
Your Honor, whether I am or I am not chosen as Chief Justice, I dream of an independent court that is the full, effective, and co-equal partner of the other departments in nation building. I say independent in the two senses understood in the court, in terms of institutional independence and in terms of decisional independence. Decisional, of course, is absolute. Institutional independence is supportive of the decisional independence. And I would like to point out at the outset that our mindset from the beginning, from law school, is of separation of powers, of checks and balances. It is as if the Constitution formulated a regime of hostility in government. But I think otherwise, Your Honors, because I think underlying the Constitution is the intent for cooperation, because all departments are engaged together, acting with one another in nation building. And to me, this is very important. Nation building. This should be at the mindset of every justice, judge, official, or employee of the government, that we are here to cooperate, not to be hostile to any department, official, or employee of government. And I dream of a court that is suffused with ethics and values. I was reading a column of Mr. Tamano, and he was saying that there are two kinds of jihad in the Muslim religion. The one is the lesser jihad, when they go against their enemies. The other one is the greater jihad, when you try to control yourself. And I think the area of ethics and values is the greater jihad. Pardon me for saying this, but even this council, Your Honors, does not have much focus on ethics and values, basing on your questions. In a speech I delivered at the FEU graduation, I dwelt on ethics and values. And I said that let us reform the bar examinations. Let us remove ethics as a subject. What we can do is make ethics and values a component of every subject. 10% of every subject should be on ethics and values. And all these 10% should be collated. So that will be the grade on ethics. That way, you give real emphasis to ethics and values. And I intend to talk to Justice Aquino at the Legal Education Board to stress my points because I have already written him. And lastly, Your Honors, I dream of a court that can be accessed and can be trusted because of its fairness in relation with its decisions, because of its balance in relation with the effect of its decision on all affected stakeholders, a court that is efficient, fostered by a human resource component that is very well taken care of, and a court noted for its decisional stability. All this, Your Honors, I think I will discuss at length in the course of your questioning. I don't think I have exceeded the 3 minutes, Your Honor.
You will be, if you will not become the Chief Justice, Justice Art, by 2013 you'll be the chairman of the Bar Examinations Committee.
Yes,
should not?
Your Honor.
So probably you can introduce the your proposals about legal ethics. But you will become the Chief Justice, then that's another story.
I have given notice of my intention to reform the bar examination on ethics and values. And I have also told Justice Abad that insofar as MCQ is concerned, I will limit MCQ to 25 to 30% only. The rest will be in the type of bar exam that all of us have been through. Because I think it's not the precise knowledge of the law that is important. Because the law is in the books and the books can always be opened. What is important is the approach to thinking, the manner of thinking, and the articulation. And this is what you find in the essay type exam. So I would like to go back to that.
Okay. So anyway, Justice Brown, Attorney Cayosa will be the first one to ask questions. Okay.
Thank you, Mr. Chairman. Good afternoon, Justice Brion. Now, I recall that for me, ethics is also very important. My father taught the subject for 30 years as a dean of the University of San Jose Recoletos College of Law. And I think that was one of the reasons and why when he managed the court, he based his principles on ethical standards. And more so, more than ever, there's need for us to professionalize the legal profession, improve the standard. Besides what you have already proposed, for those who intend to become members of the bar, for those who are already members of the bar, what do you propose? And what is something that you feel that the IBP should look into in order to improve the moral fiber of the legal profession?
Number one, let us place greater stress on the prejudicature program. Okay. It seems to me that we have forgotten this. The Commission, the Court of Appeals nominees do not take the prejudicature program, but I did. I went through the prejudicature, and I think this should be expanded. And this will open the awareness of our lawyers that out here is a career possibility that should be attended to, that should be open to us. Because in law school, we take up all subjects, and that does not really open the possibilities to you. But after law school, with PhilJA, I think that is the time. And the prejudicature should be wider and should be graded. Perhaps there should be periodical exams in the course of the career of a judge. If the PhilJA gives seminars should have exams. And in relation with this, ma'am, I mentioned this because I am into this already, in the topic already. If I were to be Chief Justice, in terms of the JBC, the Constitution says that the court can assign you additional duties, and I will. I will give the JBC charge, or I will include the JBC in the performance assessment of our judges, because this will go towards professionalism. I would like to see a judiciary where you rise through merits, and this is one of the ways of doing this. Of course, the IBP will always be there, and if I were to be Chief Justice, I was chapter president of the IBP in the 80s during the time of Senator Rene Cayetano. And I am aware of the dynamics at the IBP, and I would hope that the court will have closer cooperation and coordination with the IBP. In fact, to the point perhaps that they will be one of the partners of the court. Siguro po parang nakakabatang kapatid.
Maraming salamat po. Actually, I was hoping the other way around. You mentioned that you would want the JBC to be a partner of the court in assessing the performance of the judges. But I was thinking of having the court inform us of the performance of the judges so that we can best determine whether they should be up for promotion. But since I guess it's a partnership, so I think it's something that's workable. And we do put a premium on the prejudicature program. In fact, we make it a point to, in fact, check whether an applicant has acquired a grade that is above the cutoff or below the cutoff. Because we cannot presume that everyone who took up the prejudicature program has actually taken it and validly passed. So I am actually challenged by the fact that you have taken the prejudicature, and maybe we should make time to understand what the prejudicature program is so that we know what we are imposing on our applicants. Thank you, Justice. Which brings me...
May I just round off my discussion on the performance appraisal by the JBC? What I have in mind, because right now we have an internal audit office in the court. And sad to state, this internal audit office is not performing its job. Because what is intended is a management performance, not a financial performance. We have the Commission on Audit for the financial audit, but what I have in mind is the internal audit office to do the auditing together with the internal audit offices of the appellate courts, and then for the lower courts, it would be the OCA, and they would be reporting to you. They would be reporting to you so that the JBC can coordinate the performance appraisals of judges and justices up to the appellate court.
It's funny that you made mention of the prejudicature, because one of the questions that I meant to ask is, what is your vision for the Philippine Judicial Academy that conducts the prejudicature program?
My total vision, Your Honor, is not only the kind of institution that it is today. Perhaps we can have in the future a degree-granting institution. This can be the subject, they can be the focal point of masteral programs for those going to the public service in the judiciary. That's far off, I know, but at least it should be part of our dream.
Moving on to something that is closely related to the PhilJA is the Philippine Mediation Center. What are your thoughts on mediation, and how effective is this in decongesting our court dockets?
Ma'am, you know, I came from the Department of Labor, where we have an NCMB, National Conciliation and Mediation Board. And it has been very, very successful in reducing our caseload, in reducing the incidence of strikes. When I left the Department of Labor, we only had a record of 6 strikes for 1 year. Remember that in the late 80s, we had 580 plus strikes in 1 year. And one of the centers of strikes was Cebu. And this was reduced to 6. So I am a believer in conciliation, in mediation. When I was at the Court of Appeals, when the subject was first broached, I was quite skeptical. I told them, bakit makikipag-areglo yung mga yan? May nanalo na, may natalo na. But I submitted my quota of 20 cases that should be conciliated. To my surprise, 12 of these cases were settled. Kaya sabi ko, dapat yung conciliation and mediation ma-institutionalize dito sa judiciary. Not as a small office in the PhilJA, but as a separate office like the NCMB in the Department of Labor. I am sure this will significantly reduce our caseload. And of course, let us not forget arbitration, because arbitration is another effective tool that we can make use of. And I would allow arbitration and mediation even at the level of the Supreme Court if the parties so desire. I have no problem with that.
Yes, because I believe that one of the problems with the PMC is the funding, because it relies heavily on the funding from the PhilJA. So if nothing is allocated, then the PMC does not have any funds to work with. And in fact, that is a reason why the supervisors in the PMC units nationwide are not even regular employees of the court. So, you know, it makes, there's some instability in the structure. And we would welcome having a separate PMC, Philippine Mediation Center, as a separate unit within the court, and that's good to hear. There's something also close to your heart, which I believe has been in the news lately with respect to the Judicial Reform Program and the Program Management Office and the World Bank Fund. Would you care to shed light on the status of the program and the PMO?
Well, our program with the World Bank just finished. It finished on June 30 of this year. And there are still things to be undertaken. So perhaps in the near future, there will be efforts to sit down with the World Bank. But the World Bank is not the only funding agency that we have. We have the Abaroli, and I am now into discussions with the Abaroli on for seminars for judges on corporate rehabilitation. We have also the ADB. We have various seminars. We have SIDA from Canada. And I think we should take advantage of whatever assistance may come our way, subject to one condition. There should never be intrusion into Philippine government affairs. This is, if I become Chief Justice, I will tell people offhand that I don't want any intrusion. In Abaroli, for example, we had discussions before about the dissemination. When I thought my whistle-blowing project would be approved, I had discussions with them, And but I made that distinction very, very clear. The whistleblowing rule, by the way, is one that I will immediately try to activate when I get to be Chief Justice.
Thank you, Justice. My last question. Going over the 2010 audit report of the Supreme Court, it showed that there were several cases of non-remittance, of failure to declare collections in the lower courts. How has this problem been addressed, especially since it actually affects the credibility of the court and the efficiency of our collection of fees?
We have been quite strict about this because this is a money matter, and we cannot bend over backwards on money matters. I believe that there have been some dismissals. I'm not sure of the title of the case, but some dismissals of clerks of court for non-remittance. This is a problem for the clerks of court, and I think one of the problem is they may be trained in law, but they are not trained in accountancy or in bookkeeping. So my heart goes out to them, and we should try to look deeper into the problem because it's costing them their career.
Thank you, Justice. I actually appreciate the fact that you want to involve the JBC in many aspects of the Supreme Court, and I hope that even if you don't become Chief Justice, and more so if you become Chief Justice, that you would also consider us as a partner in other endeavors towards the improvement of administration of justice. Thank you, Mr. Chairman. Thank you, Justice Brion.
Attorney Lehia is next.
Thank you, Justice Peralta. Good afternoon, Justice Brion. Siguro po I should have mentioned this earlier when Justice Abad came here to be interviewed. We appreciate po the fact that the incumbent justices have more than willingly agreed to go through this process. In fact, even the testing and all that. And so, let me start with I was looking at your PDS, Justice Brion, and I was just curious, ang undergrad po pala ninyo ay math and engineering. If you are to advise someone po who wants to take up or pursue a career in law, what will you advise him as the ideal course, as a preparatory law course?
It's a mixture of mathematics and philosophy would be best. Why mathematics? Because of the logic that is inherent in mathematics. And why philosophy? Because philosophy is that science that teaches us about thinking in the areas that the judiciary dwells in, logic, morals, all these things. And but math is, I think, is very important because you get to be very precise. And what you observe is the trait that runs through our family. My wife is a chemist lawyer. My son is a computer engineer lawyer.
A bit related to that, and also related to what you mentioned earlier about incorporating ethics into the other law subjects. Brother Armin Luistro made a statement, or I think wants to introduce a policy whereby he will introduce the teaching of law even in the elementary level. What do you say to that?
I have no problem with that, Your Honor, especially if he will include ethics and values, because ethics and values is something that even antedates the elementary grades, ethics and values should start at the home. So if not in the home, it should be in the school. If we are too late now, it should at least start at the law school. But taking up law in the elementary grades, this is part of social studies and civics. And this was how I got interested into law. I get drawn into law. But can I comment about your earlier statement about being glad that we did not ask for any exception to these proceedings? On the contrary, Your Honor, when we were discussing, we said this would be a wonderful opportunity for those who will be nominated and who will appear before the JBC to enlighten the public about the Supreme Court, because that's what we do not have in the past. The court speaks only through its decisions. That's the firm belief that we have. And now, here comes this golden opportunity. Tatanungin nyo kami tungkol sa ginagawa namin. Ano bang ginagawa nitong husgadong ito? Tuwan-tuwa kami kasi mailalahad namin sa inyo ang aming professional life. Anong nangyayari sa amin sa pang-araw-araw sa isang linggo. At ito naman alam na ninyo, pero hindi alam ng greater public natin. Kaya for better communication, napakaganda nitong inyong pinasimulang ito.
Sa katunayan po, medyo doon ko po gusto ring patunguhin yung unang nabanggit ko kanina. Total, nabanggit na rin ninyo. At marami po ang nakikinig sa ating mga kababayan. At alam ninyo, napakaganda po na naririnig mismo sa inyo sa inyong mga justices. Ano? Kasi po, ang karaniwang kuro-kuro po ng taong bayan ngayon ay nagkaroon na ng kawalan ng tiwala, yung loss of confidence. Kasi alam naman po natin, ang rightly or wrongly, ang sinasabi ng taong bayan, yung lakaran sa huwes, ang corruption, paano po natin matitiyak o mabibigyan ng assurance ang taong bayan na kapag kayong naging Chief Justice ay magkakaroon ng isang genuine reform pagdating po sa ganitong problema?
Meron po akong isang plan of action diyan. Ngunit bago ko puntahan niyang aking plan of action, sabihin ko po sa inyo na yung graft and corruption is not purely a judiciary problem. It's a societal problem. May cultural problem po tayo riyan sa mga pakiusap. Yan po ang graft and corruption na walang bayad. Pero graft and corruption din yan. Meron po namang may graft and corruption na may bayad na sinasabi nila. Naririnig ko pero wala naman akong first-hand evidence. Ngayon, yan pong graft and corruption na may bayad, there are three parties. One, the client. Number two, the lawyer. And number three, the court official. Bibigyan po ng pera ng kliyente yung abogado o mag-a-advance ang abogado, saka ibibigay sa court official. Yan po ang standard. Pero may isang special na graft and corruption na hindi naririnig ng publiko. Yung pong graft and corruption na dadalawa ang parties. Ang parties po lamang ay yung kliyente at yung abogado. Wala po yung court official. Yung abogado pumunta lang sa kanyang kliyente, pagkatapos manalo ng kaso, at ang sabi, abay, kailangan natin bigyan si fiscal, si judge, si justice. Maniwala po kayo, nangyayari talaga yan. Naririnig kong nangyayari. Kaya dyan, ito sinasabi ko sa inyo, masakit ang loob ko. Kasi lahat po ito napapataw sa judiciary. Hindi po naman, hindi ganong kasama ang miyembro ng judiciary. Napakarami pong malinis na malinis. Sasabihin ko rin po sa inyo, meron talaga naman pilyo. Hindi po ako tumatanggi. Hindi ko lang makuhaan ng ebidensya. Pero kung kami po ay makakakuha ng ebidensya, tutuluyan namin yan. Katulad ng ginawa ko nung ako'y nasa Department of Labor. Yung NLRC, sabi ko sa NLRC, nung ako'y umupo as secretary, sabi ko sa kanila, wala na tayong kapilyuhan dito. Kung ano mang ginawa nyo nung nakaraan bago ako dumating, I will not proceed against you. Tabula rasa tayo. Pero pamula ngayon, huwag kayong gagawa ng kalokohan. Nakahuli po ako na isa. Entrapment, isang commissioner. Out. Yan po at yan ang gagawin natin dito sa Adikatura. Kaya nga po, sabi ko, ang kailangan natin dito, kooperasyon sa executive, sa legislative. Katulad po rito sa panghuhuli ng graft and corruption. Kaya po ba namin o kami na lamang? Naririnig namin, walang ebidensya. Kung halimbawa po, ako'y nakikipag-usap kay Secretary Laila de Lima at sabihin ko sa kanya, Madam Secretary, there is probable cause na may nangyayari rito sa isang kaso na ito. Pwede bang tulungan mo kami? Pumunta tayo sa huwes at humingi tayo ng kaukulang order at ang NBI na nasa ilalim mo ay kami ay tulungan. Yan po ang cooperation na sinasabi ko. Kung mangyayari po yan, makakahuli po tayo. Yan po naman palagay ko, kinakailangan lamang na ang ating publiko, I think the public also needs to be assured, only assured, that there are no shenanigans occurring within the judiciary. Hindi na po yan maglalagay. Bakit yan maglalagay? Kung hindi naman kinakailangan. So, iyan po, pagtutulungan ng lahat. The public, the media, and the different branches of government. Yan po ang aking napapaloob doon sa aking plano. Pero unang-una po sa aking plano ay yung whistle-blowing rule. I was the head of a committee that formulated this whistle-blowing rule. Unfortunately, hindi po na-approve. Hanggang binawi ko na. At sabi ko, tingnan nga natin uli. Kasi hindi ma-approve. May mga kumukontra. But hindi po natatakot sila sa whistle-blowing rule. The problem was turf. Turf problem. Merong opisyong mawawala ng poder sa pag-iimbestiga ng kaso, yan ang pinag-aawayan. Kung ako'y Chief Justice, abay wala ng away, poder ko na ito. Ang whistleblowing sa akin pupunta. O edi mag-object kayo sa... Yan po ang ano. Pero tingnan ninyo itong whistleblowing rule. By telephone, by email, basta mapoprobahan nating totoo na nagre-report, iimbestigahin po natin under the rule of confidentiality. Napakalaki po ng impact nito sa judiciary. At tinitiyak ko sa inyo na kung hindi man natin mapapaalis agad-agad, maraming matatakot diyan sa mga pilyo.
Opo, yun na po sana yung last question ko, kaya lang may nag-text. Siguro nakikinig po siya. Siguro ito na yung last question ko. Sabi niya, is it graft and corruption if a person asks a judge or justice to decide on what is right? Thank you po.
Wala po namang hinihinging masama, so hindi po naman siguro graft and corruption yan. Pero may, kahit yan kung maaari, huwag na nating gawin. Paila ng motion for early resolution. At ito po ang suggestion ko kay Senior Justice Carpio tungkol sa mga sulat. Ang dami po sumusulat sa amin At ang sulat ay problema na. Alam po ninyo, sulat ni Estelito Mendoza ay problema. Ang sabi ko, let us have a uniform action on these letters. Ibalik natin. Sabihin natin, whatever you want, ask your lawyer to file the proper pleading. Huwag yung sulat na ganyan. Kasi ang totoo, hindi po unfair. Unfair po. Hindi patas na ano. So, kung ako po yung magiging Chief Justice, isa yan sa mga gagawin ko. Pag may susulat, meron na akong form letter. Ask your lawyer to submit the proper pleading.
Salamat po. Thank you, Justice Peralta.
Justice Lagman.
Thank you very much, Mr. Chair. Justice Brion, good afternoon. I heard you mentioning about a dream court. a dream court. You mentioned earlier about your dream court. Okay. If you will become the next Chief Justice, how are you going to make your dream court a reality?
I think if I become Chief Justice,
Yes.
I will hit the ground running in making this a reality.
Yes.
Number one, I have a plan of action. For example, on the matter of delay, I have a plan of action. On the matter of graft and corruption, I have a plan of action. For PILJA, for JBC, for the Integrated Bar of the Philippines, I have a plan of action laid out. It's a question of prioritization, Madam. Katulad po nitong case backlog natin. The problem is almost in crisis proportions, if I may look at it that way. Because my researchers tell me that this is a problem that date back to the 1980s. Nakikita ko po yung mga sinusulat ni Justice Vicente Mendoza na ito na ang problema. Hanggang ngayon, ito pa ang problema. Tapos, lumalaki pa ng lumalaki ang problema. Ngayon, marami po namang solusyon. Doon sa aking pakikinig kahapon, narinig ko si Justice Hermosissima, ine-explain niya kung paano yung mga courts na hindi na natin, walang mga aplikante, sana maililipat natin sa Maynila. But that needs legislation. Isa pong kailangan din siguro ng legislation, can we have or establish hybrid courts? Hybrid courts.
Hybrid? Okay.
Yung pong, katulad po sa tawi-tawi na walang husgado. Ang kaso po naman, may by jurisdiction.
Yes.
So may MTC, may RTC. Gumawa tayo ng hybrid courts. Pwede sa RTC, pwede sa MTC. Ipasok natin doon. So legislation po yan. Ang hindi po nangangailangan ng legislation, yung po tinatawag kong substantial claims court. In contrast with small claims court. Itong substantial claims court, para pong susubukan na rin natin yung procedures sa small claims court. Pero hanggang 1 milyon lamang.
Okay.
Hanggang 1 milyon ang So RTC po ang mag-handle diyan. And then ito po naman ay mapapalawig natin. So pagdating ng panahon, yung pong sinasabi ni Justice Abad na simplified procedures in our second level courts, yan po, it will be all over. Pero unti-unti ang ating approach. Ang pinagdidiferensyahan po namin ni Justice Abad a matter of approach. Ayoko pong bigla. Sabi ko, dahan-dahan. Because the impact of a failure would be terrible on the justice system. So, tama na yun sa small claims court. Nasubukan natin. Subukan naman natin substantial claims court. Tapos mayroon na rin po tayong sa IP, intracorporate dispute. Lumalawig na po Lumalawig na.
Claims.
Kaya pagdating ng panahon, sanay na ang ating mga abogado, ang ating mga litigants. So, iyan po ang aking plano. Meron po akong individual plan of action na gagawin.
That's very good, Justice Brion. Now, I also heard you saying about the participation of the court in nation building. Can you further elucidate that? How can the court participate in nation building?
The court participates in nation building because law is the glue. The Constitution is the glue that binds this nation together, and the court is the guardian of the Constitution through the rule of law. And it is the court who provides stability to this society because disputes are inevitable among individuals or between government departments and offices. It is this court, the judiciary, that provides the solutions and stability. And to my mind, Your Honor, this is a very significant contribution to nation building. Hindi po mabubuo ang ating bansa kung ang mga components nito ay nag-aaway-away at walang referee na nagre-resolve ng mga away.
So that is it. Okay, Justice. Now, high esteem and respect of the courts guarantees the stability of the administration of justice in our country. If you become the next Chief Justice, how do you intend to promote high esteem and respect for the courts?
High esteem and respect for the courts
Yes.
is not something that we can achieve through the media.
Okay, yes.
High esteem
I
and
agree
respect
with you.
for the court are available only through substantive delivery
Yes.
of our functions. What is the function of the judiciary? It's essentially adjudication.
Yes.
So to my mind, the clogging of the dockets is a problem of crisis proportions. Diyan tayo nakikita ng mga publiko natin.
Yes.
Ang kaso nila nagtatagal ng 5-10 taon. Ay talagang hindi po maniniwala sa atin kung ganyan ang nakikita sa natin. Kaya dapat ating isinusulong yan ang isinusulong. Marami pong problema eh. Mayroon po tayong systemic problem galing sa Constitution, ang iba nitong ating mga systemic problems. Yung pong Article 8, Section 1, yung expanded jurisdiction ng Korte Suprema, napakalaking problema po yan eh. Kung inyong tutuusin, sapagkat maganda nga na grave abuse of discretion in any portion of the government. But let us remember that provision was intended to address only a specific need, yung political question doctrine. But the way this was implemented, lahat na lang sinesersyurari.
Yes.
Interlocutory order sa ibaba is a certiorari. So, this is something that we should remedy to the extent, right now, to the extent that we don't need a constitutional amendment. Yan pong, yung pong ating kakulangan sa korte. Ang budget po, ako'y natutuwang sabihin sa inyo na ang budget ng judiciary ay pinaunlakan po ng Pangulong Aquino, yung ating request for additional budget. Sa ngayon po, ang budget natin ay 1.21% na of the national budget. It used to be 0.8% only.
Yes.
So may 0.4 increase po yan. So ito po siguro ay ating mapapaglaruan upang mapasulong yung ating mga problema.
Okay, Justice. Also, one thing that I asked Justice about this morning is about the delay in the disposition of old cases in the Supreme Court. And he admitted that indeed there are old cases which are still pending with the court. If you will be the Chief Justice, how can you remedy that situation?
Nakakatakot po yung mga old cases na yan. Buksan lamang ninyo, hihikain na kayo.
What are we going to do if you will not open it?
Inaaktuhan na po ng husgado yan.
Okay.
At ito po sa ngayon, si Senior Justice Antonio Carpio, may mga ginagawa na pong may mga panukalang hakbangin na inaprubahan na po ng NBank. Katulad ng pagkuha ng additional lawyers. Tapos katulad ng magkakaroon po kami ng isang pool of lawyers, and the oldest cases will be given to that pool. And those who are old enough in the court are harking back to the time of Chief Justice Fernan. Ito daw po ay ginawa na rin nung panahon ni Chief Justice Fernan, yung mga backlog of cases ay in-address with great success. Kaya sabi namin, bakit hindi natin tingnan yung ehemplo ni Chief Justice Fernan at yung ating magagaya, applicable pa, gawin natin, and then magpasakit tayo ng ulo, tingnan natin kung ano pang ating maidadagdag. Kaya umaakto na po kami riyan.
Okay. One more thing, Justice. Now, what to you is accountability? What is your thoughts about accountability? How can you promote accountability in the judiciary?
Accountability is a constitutional mandate.
Yes.
It's not a question of promoting accountability.
But that's it.
It's a question of complying.
Yeah, that's on paper.
Yes.
But we
yes.
have not complied with that.
And I would like to tell our public and you, Madam, that we have been taking steps along these lines individually and as a court. I say individually because the day after the decision of a day after or two after the decision in the impeachment trial,
Yes.
I found Ombudsman Chit Morales and I told her, sabi ko, padadala ko na sa iyo yung waiver ko, bahala ka na. So even before, and Justice Villarama also did this. There are some others I may not know of. But even before the court made a formal waiver of their disclosures, and then significant steps on individual basis have been already taken. Pero talaga pong kailangan natin na yan. Yung transparency is a need that is whose day has come. Kaya dapat po seryosohin na natin. Lamang, ang transparency po is not a magic word.
Yeah.
Na lahat po ay ipakikita na lamang natin sa publiko, sa madla, sapagkat we have many concerns to think of. Concern for the nation, concern for the court, and concern for our individual selves. You know, Madam, if we, in the past, well, this happened before our time, did not want to disclose our salens, I understand that this was because of concern for the independence of the court. Naririnig na rin po sa lower court judges noon pa na they will be harassed if their salens will be disclosed to everyone. Ngayon nga po, meron kaming disclosure policy. Sabi namin to everyone. Alam po ba nyo kung nangyayari naman ngayon? Hindi naman media lang ang nanghihingi. Ang dami po naming request sa mga estudyante. Pag-aaralan daw nila, assignment daw nila sa kanilang profesor. Sabi ko, ano bang gagawin natin dito? So, I think we ended up putting up guidelines and we are making the disclosures as needed if this would be necessary for the preparation of academic papers. So, yan po these are my thoughts on the matter.
So my last question, Justice Brion. As a Chief Justice, if you will be fortunate to be appointed, how do you want to be remembered?
I want to be remembered,
As?
well, perhaps people can say, well, Art Brion was here and he did his bit for the nation and for the judiciary. But sa kabuuan po, sana po ay yung aking sinabi kanina, ng aking vision for the court, na participant in nation building, an independent one at that, our emphasis on ethics and values, and fairness, balance, decisional stability, lahat po makuha natin. Yan po naman sa tingin ko, kung hindi man 100% nating makukuha, ay sa malaking kabuuan po. Kaya natin. It's a question of focus and will. And with focus and will, we can achieve almost anything. Nakapagpapayat nga po ako sa focus and will.
Yes. You're so trim now. In a matter of months, is it not? The last time I saw you, you're so big.
I lost, well, I don't mind telling the public, with the guidance of my doctors, hindi ko na lang sasabihin kung sino ang doktor ko, at baka naman sabihin, pinag-a-advertise ko. I lost 60 pounds
Wow.
in 10 months.
10 months? Wow.
10 months. And I ascribe that to the focus and will to slim down.
Okay. So on that note, I don't have any more questions for Justice Brion. Good luck, Justice.
Justice Hermosissima, sir.
Good afternoon, Justice Brion. Your reputation for integrity and competence has preceded you, sir. It will be remembered that Justice Brion applied for the Court of Appeals. When I read the PDS that he filed, I told my colleagues, no, you include him in the list for applicants for the Supreme Court. Justice, there is one concern that I have, especially when I was still a member of the court. Cases which are not necessarily decided unbanked are decided by a division of the Supreme Court. The decision of the ponente in that division is a decision of the whole court. There are objections to this manner of deciding cases because it is felt that the decision of a division is not reflective of the sentiment of the whole court. What are your thoughts on this matter? Would you agree that all cases be decided unbanked instead of by division?
I agree with you, Your Honor. Cases in the Supreme Court should be decided en banc. And for that purpose, I will propose to the court that we restructure ourselves into divisions of three. So that there will be 5 divisions. And these 5 divisions will accept all new petitions for what we call our filtration process, for purposes of completion, and for purposes of a report and recommendation to the en banc. So, cases will move fast. There are only 3 members to a division, and there will be dismissals of cases, and there will be reports and recommendations, and this will all go to the en banc for the en banc's consideration. I say that I will propose this to the court because this is quite a radical proposal, because I don't think we have ever constituted ourselves as divisions of 3. But this is one of the answers to our clogging of cases. Things will move faster. And this is not at all a problem, because what will happen then is that the en banc will simply concern itself with deliberating on the finished reports of justices. I think in one en banc sitting, 20 to 30 cases would be a possibility. Of course, there will be some problem cases that will be called again and again. But these are the major cases that even with our present structures are also called again. But this will serve, Your Honor, the problem that we have about conflicting decisions.
Yes.
Alam po ninyo,
Good point.
may umaga, mauunang magbasa sa akin ang misis ko. Ang sasabihin ng misis ko, dinesisyon na pala ninyo itong kaso na ito. Sabi ko, hindi ko alam kung ano yan. Hindi ko po alam sapagkat ibang dibisyon ang nag-decide ng kaso. Yun po ba mababasa ko pa? Hindi ko na ba mababasa yun. May desisyon na. Sa dami ng aming kaso, with what I propose, all cases will pass through the en banc. So lahat en banc decisions na. So cases hopefully will not only move faster, there will be a uniformity of rulings aside from stability of the tenor of the rulings in our cases. If we have to change principles of law, then that would be the opportunity also, because everybody will be contributing. So, yan po ang sagot ko sa inyo, Honorable Justice.
Thank you very much. Now, there's something that has bugged me. Considering the unmitigated proliferation of deaths caused by violence of judges, journalists, and other private individuals, are you in favor of a revival of the death penalty law? Do you believe that the extreme penalty of death is a deterrent to the commission of such crimes as murder, parricide, rape, kidnapping?
I am really neutral to the idea, Your Honor. There are pros and cons against the idea.
Precisely.
It seems
That's
to
why
me
I'm
that
asking the question.
the death penalty is not at all a deterrence, considering the delay that occurs before the death penalty is ever implemented. Kung yan pong death penalty, katulad ng ginagawa nila sa China, na mabilis, ikaw pa ang bibili ng bala, siguro deterrent yan. But in our system of laws, that is unknown. Ang kinatatakot ko po lamang sa death penalty, kami po ay maaring magkamali. I have been reading an article about innocents in the United States, not here, who are now languishing in the death cells of their penitentiaries. Sabi ko, malaki din namang kargo ng konsyensya natin kung magkakamali tayo. Pwedeng magkamali. Pag tinimbang ko po ito, para sa akin po, bagamat yung mga guilty ng heinous crimes, talaga pong dapat naman sigurong malipol na dito sa ating society, I would go for the lesser reclusion perpetua without possibility of parole.
Well, consider, Mr. Justice, that quite recently the Federal Supreme Court of the United States upheld the constitutionality of the death penalty. This in spite of the opposition of American bishops to the imposition of the penalty of death. But yet 4 Catholics in the court voted in favor of the imposition of the penalty of death.
I have no problem about the constitutionality of the death penalty. I think it is constitutional. Pero yung sinasabi ko po sa inyo is based on my system of values. In case of doubt, in case of the possibility of mistakes, siguro po doon sa area na yon, pwedeng tingnan natin kung anong ating magagawa. Pero kung pwede po tayong magkamali, sana po reklusyon perpetua na lamang.
Now, on another matter, Mr. Justice Brion, I think this is really important, and I do believe that you must have taken a stand on this when this was brought up to the Supreme Court. You see, this City of Manila Ordinance Number 8027 reclassified parts of Pandacan from industrial to commercial zones, thus mandating Pilipinas Shell, Chevron, and Petron to transfer their operations elsewhere. Yet, the Manila City Council subsequently approved Ordinance Number 7177, which allowed the big three oil firms to continue operating the oil depot in spite of the... Now, those who want the transfer argue that the oil depot poses a danger to the life and limb and the safety and health of the Manila residents. Not only Manila, but also the suburbs. It might cause a disaster and devastation of Manila and suburbs, a devastation which can cause something more serious than Typhoon Sindong. But yet, those who favor the retention say that this will increase the price of gasoline, because one half of the gasoline consumed in the country comes from this. And if you transfer this, it will cost a great amount of money. And then it will deprive the about 36,000 employees of their jobs, and especially the city of Manila will lose the revenue of 96 million pesos. So, what is your stand now, and what will be your stand when you become Chief Justice?
Alam po niyo, Justice, until 10 months ago, ako po ay sa Pandacan nakatira.
Yeah.
Sa ilalim po ng isang tangke roon, malapit kami sa tangke. Kaya ako po ay ipinanganak sa Pandacan. Ako po ay lumipat na sa Pandacan pa rin naman ako sumisimba, at yung mga dati kong kapitbahay ay siya ko pa rin mga kasamahan ngayon. Ay kaya nung dumating po yan sa Korte Suprema, ako po ay nag-inhibit. At sabi ko, malaki po ang problema ko Ang aking pong kaisipan ay sinasabi na tanggalin na natin yan. A depot has no place in the middle of the city.
The middle of the city.
It has become an anachronism. Pero meron po akong interest na pang sarili. Kasi nandun po bahay ko ayon po sa ating rules of court, in that situation, I must inhibit. And I did inhibit. And I will again inhibit. Kaya ipagpaumanhin po ninyo, yun po ang kapasiyahan ko ron.
On that note, thank you very much.
Secretary Mosgi.
Justice Brion, magandang hapon po. 2 days ago, His Excellency the President delivered the State of the Nation address before the Filipino people live on television. You are an aspirant for the position of Chief Justice. If you were Chief Justice, how would you summarize the state of the judiciary right now?
I would say this. The judiciary right now is an institution that is perceived to be problematic. Talaga pong meron kaming problema. Hindi po itinatanggihan. Meron po kaming problema sa number of our cases. There is also that perception of graft and corruption. Tapos po, kabi-kabila na sinasabing wala na raw pong tiwala ang bayan. But these are the negatives. I can also count the positives, and there are so many positives. Among the positives are the honest judges and officials who are laboring out there all over the country. Ayoko po namang sabihin sila ay parte ng isang masamang hudikatura. Kahit sa Supreme Court na naman po ay sabi nila ang Supreme Court daw ay masama ang naging effect nitong impeachment trial. Hindi po ako naniniwala. Hindi po ako naniniwala dyan. Para pong nangyari sa Supreme Court ng impeachment trial ay isang tao na pinalo sa ulo. Sapagkat ang ulo po namin ay si former Chief Justice Renato Corona. Pag kayo po ay pinalo sa ulo, pwedeng kayo ay maliyo, pwedeng kayo ay matumba. Huwag lamang kayong mamamatay, kayo ay buhay. At panahon po lamang ang kinakailangan. Na yan namang panahon yan, sa palagay ko ngayon, ay lumipas na. Buhay na naman po ang ating Korte Suprema. At sasabihin ko, ang Korte Suprema natin ay malakas. Kailangan po lamang natin ng isang malakas ding liderato upang ang Korte Suprema ay makapunta kung saan ang dapat niyang talagang puntahan. Yan po ang sinasabi ko na aking mga plans of action, and sinasabi ko rin na kayo mga nasa JBC, including the Chief Justice, when and if you are granted the power of performance appraisal, performance assessment, you should be able also to assess the performance of the Chief Justice. Yan po, pagdating ng panahon, magiging very powerful tool po para ang ating judikatura ay mapausod. Pero ang ating pong Supreme Court ay naliyo po lamang out of shock, tulad nga po ng isang pinalo sa ulo. Pero ngayon po ay buhay na naman. At normal po ang aming operasyon. Wala po lamang Chief Justice. Magkaroon po lamang tuloy-tuloy na yan. Tuloy-tuloy. At pagkat ang ating po namang Supreme Court ay isang buong-buo. We are a collegial court. We have different beliefs. We come from different backgrounds. We have different strengths and weaknesses. But if you sum up those strengths, kami po ay isang malakas na husgado. Katulad po kanina, narinig nyo si Justice Abad. What is his strength? His strength is in his trial advocacy. Ano po yan practitioner na napakatagal na panahon. If I were Chief Justice, I will harness his potentials, his capability in the areas that he wants to act on. Patutulungan ko po yan kay Justice Bersamin at kay Justice Peralta. Justice Mendoza, ito po ang mga veteranong, hindi po ano ito, pero veteranong mga justices natin sa ethics and values. Sinong pagbibigyan natin yan? Si Justice Bambit Mendoza. Meron po kaming seminarista. Seminarista, talagang simpleng-simpleng tao na pag pinagtiwalaan mo ng ganyan, gagawin ang kanyang Iba't iba po, iba't iba. Perhaps no one justice would have a monopoly of all the attributes that a perfect ideal magistrate should have. Pero meron po kaming kanya-kanyang dalang kakayahan. Katulad ko po, ako po lamang siguro sa husgado ngayon ang galing na sa buong gobyerno ng Pilipinas. Ako po ay galing sa legislatura, galing po ako sa executive, ngayon ako ay nasa judiciary. Kaya malakas po akong sabihin, malakas ang loob na ako na sabihin ko na there should be cooperation among the departments of government because I know that that cooperation is achievable. If I were Chief Justice, I will have no qualms about approaching Congressman Tupas. Sabihin ko sa kanya, Congressman, ito ang pangangailangan namin ng mga husgado. Ito ang mga pagbabagong kailangan natin sa husgado. Wala pong problema. There is nothing wrong in doing that. Because while we are independent, our absolute independence relates to our decisional functions. Hindi po ibig sabihin, hindi na kami makikikooperate sa ibang departamento ng gobyerno ng Pilipinas. No man is an island. Pag nawala po ang isa dyan, may problema po ang ating bansa. At ang unang-una po, ang ating iisipin ay yung ating bansa. Sapagkat ang bansa po natin iisa. Masasabi ko po yan sapagkat ako ay nag-immigrate. I spent 7 years in Canada. And I would say these were 7 very lonely years. Wala akong bansa. Hindi ako umuwi ng Pilipinas. Hindi pa tapos ang aking mga anak. Natatakot ako na kapag ako ay umuwi, baka hindi na ako bumalik doon. Kaya ako po, I could relate to the OFWs who were the clienteles of the Department of Labor because I could place myself in their positions. So yan po ang aming strengths and weaknesses. Yan po ay pag pinagsama-sama yung strengths na yan, malakas na husgado po ang nasa sa atin. Yun po ang state of the judiciary ngayon. Meron po kaming kakulangan, hindi po itinatanggi. Ang sinasabi po namin, tulungan ninyo kami para yung aming kakulangan ay mapunuan.
Thank you po, Justice. Your Honor, moving on, if I may, I'd like to ask you what you think of two very basic concepts in law. One is judicial independence. The other is judicial accountability. Do you think that these concepts are complementary? Are they to you exclusive? Or do they, in your own opinion, competing? May I solicit your views on this?
In my mind, these are not competing concepts. When we speak of judicial independence, as I said earlier, there are two aspects to it. The first is institutional independence, and that is the independence of the Supreme Court as a body. And there is the independence of every justice in the course of preparing his or her decision. Yan po hindi nagkukumpit dun sa accountability. Ang accountability po naman yung ating pagsunod, yung pagsunod sa ating mga kinakailangang gawin. Number one, katulad po ng SALN. Ang purpose po ng SALN matiyak pamula sa report ng sarili ng isang opisyal na siya ay hindi nagpayaman sa kanyang opisina. How can it compete with independence? From that point of view, sir, I don't think there is any conflict. I would call them complementary to each other for a better and stronger judiciary.
Thank you po. Justice Brion, I have two more questions, and the next one is, I beg your indulgence for some data na I want to share with you. Please correct me if I'm inaccurate with my data. This is about addressing case congestion and delay, which are very important issues right now. If I may, I would like to start out by saying that the judiciary has been recognized as consistently being pointed to low budget as constraints in the performance of their duties. Sinasabi, hindi magawa ng hudikatura ang kanilang trabaho dahil walang pera, maliit ang budget. But sa research po na amin, some data will show that the judiciary's budget has in fact doubled since 2004. I can give you more exact figures on that. But as part of my question, despite this, clearance rates in the judiciary have actually declined. For example, sir, Your Honor, the number of cases decided by the courts in 2010 was only 60% of what were decided in 1999, with even fewer judges. And clearance rates dropped from 43.5% in 1999 to 37.8% in 2010. And the backlog grew from 56% of cases in 1999 to 63 in 2010. Again, I'd like to pursue this by saying that the outputs of lower court judges decreased from an average of 334 cases in 2004 to 207 in 2009. Your Honor, what do you think are the underlying causes of this increasing inefficiency? What measures will you put in place over the immediate term to solve this? And if I may even ask, what long-term solutions can you plan ahead?
This is the first time that I have read this kind of report, and it surprises me really. But let me tell you offhand that what we are speaking of here would be the performance of human resources, because our judges and justices and officials are our human resources. I would first look for problems in our human resources. What can be the problem? My answer right now is I do not know what the problems are. Perhaps it can be that the resources, financial resources available to the judiciary are not trickling down to the lower courts. That I have to find out, but that is a possibility. Perhaps there is demoralization at our lower ranks. I don't know, but this is something I can address immediately. Aside from our human resources, we have to look at our facilities and equipment. But again, this is a function of the budget. I understand that our lower courts right now are still deficient in halls of justice, in equipment, and this is from the reports we're getting from the World Bank. And that was not the report I was getting from the World Bank. But let me just tell you that the first step in any solution of a problem is to find out what the problem is. So if you were to give that report to me and ask me to work on it, to apply remedial measures, my first step is to verify. Are these correct reports? If these are correct reports, where are these deficiencies coming? That would be what I would call the identification of the problem. With the problem identified, then we can go into the first step or short-term solutions, the second step or mid-term solutions, and the long-term solutions. Unfortunately, I cannot give you any of these solutions right now, except in a very, very general way, because I really don't know the extent of the problem that you outlined to me. But in terms of long-term solutions, well, legislation is one, increase the number of our courts. Number two, on the immediate solutions, if it's a problem of the human spirit, if our judges are demoralized, then as Chief Justice, I am willing to go out there and talk to them. I can have motivational speakers with me, like Francis Kong. We identify the problem, we address the problem. Our judges are periodically going to Tagaytay for their seminars. Ay ano ba namang yung Chief Justice, every now and then, puntahan. Bawat batch ng judges, puntahan doon at kausapin. Ano bang problema? Ginagawa ko yan nung ako'y na Secretary of Labor, na kahit saan ako pumuntang bansa, I make it a point to have meetings with my people. Hindi social meetings, but business meetings with my people. Ano ba ang problema natin? E nakikita ko, it uplifts their moral na sila ay iniintindi ng pinakamataas sa kanilang organisasyon. Kung hindi naman bumababa ang budget ng kung hindi bumababa ang budget ng judiciary sa ating lower courts, that's another problem. But it is an administrative problem that we can remedy. So matotal, Your Honor, may remedyo.
Thank you po. If I may, just one more question, Mr. Chairman. You have stated, Your Honor, that you are a judicial pragmatist rather than a judicial activist. Can you explain to us what this means, and which decision which you wrote do you think is the best example of this, and why?
A judicial activist is one who stretches the limits of the law in applying his actions in his decisions. Yung pong ginawa ni Chief Justice Puno na writ of amparo, writ of kalikasan, writ of habeas data. These are samples of judicial activism. This is something that can be done through legislation, perhaps, through another way. But the Chief Justice was very imaginative. and he used procedures, and procedures are within the competence of the Supreme Court. So he was being a judicial activist when he did that. When I say I am a judicial pragmatist, hindi po ako conservative, hindi rin po naman ako activist. But I remedy the situation as I see them. I have solutions within the confines of what is possible based on what is needed. Ang isa ko pong desisyon na bordering on activism, pero I would still call it judicial pragmatism, ay yung pong desisyon ko sa Tagitis versus Rason. It's a writ of amparo decision where I said that after considering the totality of the evidence adduced, one evidence, hearsay evidence, should be admitted despite the prohibition in our rules of evidence against hearsay evidence. And my reasoning was that kung totoo naman, kung sa kabuuan ng mga ebidensya, ang itinuturo ay tama yung sinasabi nitong witness na ito, ay siguro ay pwede nating i-admit. Ang naging problema po doon, yung isang koronel na nagbigay ng testimonya, hindi testimonya, nagbigay ng statement sa asawa nung nawala, ay naambus ng Abu Sayyaf, namatay na. And sabi ko, admissible yan. Kahit nung bago mamatay. So this is perhaps an example of my approach, my judicial thinking in solving problems.
Again, thank you very much, Your Honor.
Good afternoon, Justice Art. Believe na ako sa'yo, pinagbilib mo pa ako eh. Meron akong few questions, Justice Art. You were talking about your health. How is your health? You reduce considerably your weight. Are you sick?
I am not sick. In fact, I am at my healthiest in the past 40 years. I have struggled against my weight for a long, long time. When I got married, I was 180 pounds. I went to law school. After the bar, I was 225 pounds. Tuloy-tuloy na yun, umakyat ng umakyat. Until the point when I got into the 270 and even 280 pounds. So it was a real problem. Until my doctor talked to me, and he said, Art, you are a dam about to burst. Sabi ko, what must be done? Sabi niya, isipir mo na yung bibig mo. So, with his help, I was able to reduce. But weight reduction is a problem only in the first 3 to 4 weeks. After that, it's not a problem anymore. Simply because our body adapts, our stomach shrinks. When the stomach shrinks, you cannot eat the same amount of food that you used to eat before. So it was, in effect, a problem that solved itself. The downside, naubusan na po ako ng damit.
I was thinking that you reduce weight because you might be probably preparing to a bigger role. You prepared yourself for a bigger role. Bigger role.
I started reducing in September of 2011.
So you did not anticipate, no?
I did not
Did not
anticipate,
anticipate, yeah.
and
Now, you were talking about the prejudicature program that it should be incorporated. That program should be used as a measure in promoting those already in the judiciary. You cited an example, those who are going to the Court of Appeals from the RTC, they should undergo this program, you know.
Yes.
You want it to be mandatory. Yeah.
It's supposed to be mandatory now, but it is observed more in
Mandatory
the breach.
provided for by what? It is mandatory provided for by what? By a resolution of the court or what?
By a law, I think, Justice Hermosissima. The prejudicature program.
I think it's a law.
The prejudicature program is a law. The law says that only applicants who have passed the prejudicature program may be appointed by the chief executive.
Because I was thinking
But
that
there are times when we don't apply that, because if there are no applicants who pass the prejudicature program, then we are free to nominate those who have not passed the prejudicature program. But where there is an applicant who passed the prejudicature program as against one who did not, then the prejudicature program, the law prevails.
okay. Now, do you suggest that we come out with a resolution that the prejudicature program is a must for those who would like to be promoted to the Court of Appeals? Because we might not have control about the applicants coming from the outside. But
No.
for those already, the court, those who are vying for a higher position, can we come out under our rule-making power, come out with a rule under our rule-making power to make a prejudicature program mandatory for purposes of promotion?
The prejudicature program should be mandatory for those coming from the outside. For those coming from within, perhaps it's a question of qualification to qualify for a position. If you are an RTC judge and then you do not qualify, then you may have a problem.
No, but
But
what I was saying is that you're an RTC judge, you want to be promoted to the Court of Appeals.
Take the exam.
Take the exams. Now, my next question is, can we, if you know the Chief Justice, will you be willing to come out with a resolution under our rule-making power under Article 8, making mandatory this program for purposes of promotion from the RTC to the Court of Appeals or from the MTC to the RTC?
Absolutely.
Absolutely.
But let us take a deeper study of this, because there may be ramifications that we cannot see right now. But essentially, that is my idea, because it will promote professionalism and merits in going to the Court of Appeals. Mawawala yung politika eh.
Oh.
And we can exhibit this to the public.
Now, another thing is that, aside from your adjudicatory functions, because I asked these questions also when Justice Robert was here, no? What other functions do you perform? Aside from adjudicatory functions, administrative functions.
In the court, I am the chair of Commercial Court Committee, and we are working right now on the rules of the PREA.
Rules of the?
PREA, Corporate Rehabilitation Law. And I am a part of Justice Roberts' academic committee. I am part of the internal rules. We are together in the internal rules committee. And
I think the ethics, you had the ethics committee? Yeah?
no, I am not in the ethics committee.
Oh.
Seems I'm not ethical enough.
Yeah. You know, for the information of the public, no. Justice Art we call him and I want him to explain why we call him Mr. Immutability. Can you explain to us, Justice Art, why you are Mr. Immutability?
I believe that for as long as we have the prohibition against second motions for reconsideration, then our judgment should be immutable after the first motion, after the ruling on the first motion for reconsideration. Right now, we have a rule that has tightened up what used to be a wide open practice before. Right now, after the first motion for reconsideration and after the denial, then you go into a second motion for reconsideration, and for it to be considered by the court, you must get the vote of at least 10 members of the court, irrespective of how many there are in the court. If, for example, there are only 12 members attending, you must still get 10. Once this is admitted, then you can, the court can vote in the ordinary way. Now, this is still perceived by some to be unacceptable. So I have now a position paper submitted to Justice Abad, providing for another petition. After finality, then we can have a petition that is almost the equivalent of a relief from judgment based
Relief of judgment under Rule 38. Yeah, that's Rule
yes.
38. But relief of judgment is not available to the Supreme Court. It's only available to the Court of Appeals.
No, we will make it available to
yeah.
our own decision, but only on jurisdictional grounds. Only on jurisdictional grounds.
What about annulment of judgment? Is that possible? Can we entertain petition for annulment of judgment
We can
in the Supreme Court?
we can make that the title of our rule.
Yeah. Because that's really a problem in the Supreme Court, because we allow petition for relief from judgment in the Court of Appeals and petition for annulled judgment also in the Court of Appeals. But we do not have any remedy in the Supreme Court. In fact, in the rule on DNA evidence, even if the accused is already convicted by final judgment and he's serving sentence, if it is found out under the DNA rule, if there is a specimen and it's declared that specimen taken from the scene or from the victim is not compatible with the specimen from the accused, and therefore there is a therefore there is an evidence that he did not commit the crime because of the result of the DNA, we can acquit and accuse. That's the rule on the DNA evidence. Is it not, Justice Art? Yeah, so correct an injustice.
But I think, Your Honor, that right now we have almost solved the
Problem,
immutability problem. It's a question now of getting into the formalities. And the worst is over after Dinagat and after Keppel. These are the...
I think you join me in the Dinagat decision?
Yes.
Yeah.
And
because he was referring to me as a member of the internal rules, then he would like that I be a member, if he becomes a Chief Justice, a member of the rules to on the rule of rules. I think he's courting my vote.
ang naging problema po rito, Your Honor, binigyan ako ng problema nung Dinagat case na yan eh. Kasi si Congressman Tupas, masyadong pilyo. Doon sa kanyang impeachment complaint, kinote pa yung aking statement sa Dinagat. At siguro natuwa siya sa sinasabi ko that in the case of Lazarus, I said, we know that resurrection came from a miracle of the Lord. In this case, I said, resurrection came from the miracle of the Supreme Court, and that I cannot accept.
Na isang tanong ko pa, Justice Art. You want that all cases will be referred to the en banc. That's one of your proposals, is it not? To the en banc. There will be no more divisions na. Okay. Is that doable considering the cases that are assigned to us? The number of cases that are assigned to us in the division, you can just imagine, no? On the average, how many cases do you receive on a monthly basis, on the average?
30 to 40.
30 to 40 for the cases?
For everything.
Including en banc?
Including en banc.
So if you get 30 cases per month, then that would be, times 12, that would be 360 cases per year. Yeah. You multiply 360 cases by 15, no? Assuming that we get an equal distribution of cases. So how many cases would that be? That would be more than 4 to 5,000 cases, and they will all go to the en banc. Is that doable? Justice Hart?
I think it is doable because the en banc will only be deliberating on the final decisions. There will be no incidentals anymore.
So the comments, reply.
There is completion in the
Court of Appeals, like in the Court of Appeals,
sense.
completion then.
You complete everything at the lower levels. Once it is submitted and there is a report, you toss it to the en banc. The en banc now reads the report and deliberates on it.
Baka may hirapan tayo dyan, Justice Art. You can just imagine, we set around 200 to 300 cases every Tuesday in our en banc sessions, no?
No, but
sometimes we did just only one case. It will take us, sometimes it take us 2 hours to deliberate and we do not arrive on a consensus.
But that would be the exceptional cases. Ngayon, yung 200 cases naman natin sa en banc, this would involve interlocutory matters. Mawawala na interlocutory matters. Halimbawa, 20 ang naka-schedule sa en banc. All these are for deliberation. Now, this will include illegal dismissals that are not hard to resolve. This would involve include criminal cases. This would include ejectment. So, marami tayong masasala na agad eh. Leaving us about...
sino magsasala?
No, tayo.
Tayo rin?
Tayo. No, hindi magsasala. Ang ibig kong sabihin, aakyat sa atin, report on an illegal dismissal case. This will be the decision.
In the meantime, you will be...
Madali yun. Madaling
in the meantime, you will be sitting as chairman of the Committee on Commercial Law.
Yes.
So, wala na tayong oras dyan.
No, kaya.
Kaya ba?
Kaya. Kasi, yun nga sinasabi ko, it's a question of focus and will. If we want to do it, we can do it. And we are in a crisis situation, I think, at this point. So let's do it.
Isang tanong ko pa, para malaman din ang publiko. Bukod sa committees natin, kasi most of the senior justices, may mga chairmanship sa committees yan eh. Ako, chairman ako isang committee, members ako ng ibang committee, ikaw chairman ka ng isang committee, si Justice Robert, Justice Test, we will be also here for an interview, chairman din. Marami tayong committees eh, hindi ho ba? Hindi ba? Hearings, hindi ho ba? Kaya mabigat ang trabaho ng Chief Justice. Bukod doon, Justice Art, if you are from the top six, hindi ho ba? Top 6. Umuupo pa tayo sa HRET eh. Yung House of Representative Electoral Tribunal at saka yung Senate Electoral Tribunal eh. Hindi bale sa Senate Electoral Tribunal, tapos na isang protest doon, yung kay Senator Pimentel. Ngunit sa HRET, Diyos ko po, ang kaso nun ang dami, co-warranto cases at saka mga protest. Hindi ba? I think, I took your position in the H threat because you are more senior than I, you went to the set. Hindi ho ba? So, tignan mo na lang trabaho sa Korte Suprema, trabaho ng Justice. Tapos ilalagay pa natin lahat ang kaso natin sa NBank, sa dami. Hindi pa tayo mahihirapan dyan.
Ang totoo, Your Honor, walang madali. Walang madali. Kasi talagang mahirap naman talaga yung posisyon eh. Pinahirap lamang natin ng konti sapagkat may problema. Hindi naman pang matagalan yan eh. Pag na-resolve natin yung problem, we go to the old system, not to the old ways.
So, ito nga ang susunod na tatanungin ko. So, iba talaga yung may experience sa work dynamics sa Korte Suprema. Hindi ho ba? Mahirap talaga. Diba? I'm not saying that those from the outside are not qualified, but what I'm saying is this. This is what really happens. This is how we work in the Supreme Court. Tama ba?
Tama.
That's why I agree with you that because of this interview, you were able to enlighten the public as what we actually do. Hindi ho ba?
Tama po.
At saka yun ang rason na pumayat ka. Hindi ho ba? Ayaw mo kasing aminin eh. Na one of the reasons na ganyan eh. Ako pumapayat din eh. I'm losing weight also because we have the same doctor. Hindi ho ba? Kaya nabawasan ka ng weight sometimes dahilan sa trabaho. Totoo po yan. Now, my last question is, alam mo, si Justice Art, magaling ito eh. Ha? To enlighten the public also, number 1 sa bar exams ito eh. Ha? Tama ho ba? Number 1 ka sa bar exams, ano? Oo, tama. Yung problema, you're already, how young are you, Justice Hart?
65, Your Honor.
65, so you have at least 5 years, no? 5 years pa. Ang tanong ko sa iyo, 5 years ka na lang dito, if you become the Chief Justice, at marami kang programs na introduce dito, hindi ba short period of time lang, 5 years na lang eh. Ha? Ang pagsisilbi mo, pwede pa?
Hindi po maikli ang 5 years. 5 years ago, I was Secretary of Labor. So, matagal na panahon.
Ayan.
Sa labor, I was there for only 2 years and I did a lot.
So plus factor ba yan sa iyo? Because according to you, of course, you will tell me that's a plus factor because you were once a Secretary of Labor. Insofar as administrative work is concerned, probably plus factor sa iyo. Naging member ka ng Batasang Pambansa, di ba? Plus factor din, tanong ko sa iyo, candidly, ano naman ang weakness mo? Lahat na ng plus eh. Anong minus? Wala, no? Justice Hart.
Your Honor, it would be an admission against interest.
Okay. So, okay. Now, ang huli kong tanong, kasi naghihinayang ako, 5 years na lang, so you have to retire after 5 years. Anong gagawin mo after retirement? Are you willing to come back to the court, probably as a consultant, help the court? Anong plano mo after retirement?
Let me tell you what I will not do.
Oh, what you will not do? Okay.
I will not practice.
But you can practice in Canada.
No.
No, you will not.
I will stay in the Philippines.
Okay.
I will not practice. I will not write a column. I might probably teach with some difference. My wife and I have been shopping around for a small community where we can locate after retirement. And we would like to teach in high school and a little of law school. And I think we have located one locality now.
Where at?
Well, we are interested in Lipa City. There is the De La Salle Lipa, where they have a very good high school, and they have an upcoming law school. Their first bar examinees will come in next year, I think.
Why not? Why not in Laguna? This is this place where you come from.
Eh,
Why in all places, Lipa?
ayoko po.
Are you a follower of Vilma Santos, Governor Vilma Santos?
No, ayoko pong umuwi sa San Pablo ng pangmatagalan. Ayaw ko rin sa Laguna because I used to be a politician and I don't want to go back to politics. So I would like to lead a simple life, teaching, perhaps writing, and reminiscing about my days in the court.
Now there are questions, given to us. You may or you may not answer. If you say that that has already been answered in your ponencia, it's up to you. Now the question is, please comment on the propriety of Mendoza's letters in the FASAP case or of retired SC justices writing personal letters. You want to answer this because I think you already came out with a resolution about the letter of Attorney Mendoza in the FASAP case. Do you still need to read this or?
Well, I don't
Wanna
mind.
answer this?
I don't mind discussing my end of that FASAP case. That FASAP case was a very unusual case. It was a case decided by a division, where of 5 members of the division, there were 3 who retired, one after the other. And after the denial of the motion for reconsideration, there was a second motion for reconsideration. It was raffled to a member of the court under an old rule.
Yeah, a member of the court who was an original member of the decision of the division that rendered the decision.
No,
No, it's not.
no,
Okay.
it's not. A member of the court who is not member of the original ruling division under an old rule. After that, it was raffled, and the case was revived on second motion for reconsideration. And then the member of the court handled the case for 1 year. After 1 year, when there came a new rule, he inhibited himself from participation in the case. And the case was raffled to me. So I decided the case, deciding in favor of the union. And to tell you the truth, I did not look into the history, the raffle history of the case. So after our decision was released, there came the letter of Mendoza asking about the history of the case. So when I went into the history of the case, I saw a problem. Wala kaming authority to rule on the case.
Because of the new
under
rules.
the rules.
Yeah.
Under the rules.
That the case should have been assigned to a member of the original division.
Original ruling
Yeah.
division.
But because we were not part of the original division, then you should not have taken cognizance of that case.
Yes.
So there was really a need to answer the letter.
So, because our decision has been issued already and time was running, we went to the Chief Justice, former Chief Justice, and informed him about the situation. And we told him that we have to recall our decision. So we went to the en banc and recalled our decision in order to avoid flip-flopping. Because had we not done that, the decision would have lapsed to finality. Ngayon, pag naging final na yan, saka mo papalitan,
Mas mahirap yun.
flip-flopping problem na naman. So, that was the root of the problem. But it came at a time when there was that impeachment move against the former Chief Justice. So it was cited as one of the grounds for impeachment. But it was really a ground that has no merit because immediately after resolution, the matter was dropped by the prosecution.
And in fact, there's no yet decision on the main case. There is no yet reversal of the decision of the division that rendered the decision, although the case is already in the en banc.
Yeah.
Okay. Now another question is they would like to ask you had a strong dissent in the Kohang Kokoko levy case, no? And you mentioned gross negligence of the council.
Yes.
And I remember right, it's not part of the question, and I remember right that you wanted to remand the case to the Sandigan Bayan
Yes.
for further trial because you believed then that the government council did not do its job. They should have asked for a period to present their evidence. No.
I believe that the counsel for the government gave away the case.
So anyway, the question now is this: no? If you are now the CJ, would you allow a revisit of that case? That case because it's already decided by the Supreme Court, no?
But
On the second motion.
That's already final.
That's
So
the-
how can you revisit a final decision? You go back to the old flip-flopping charge.
Yeah. That's why we call him Mr. Immutability. Now, there is another question. I don't know if you're familiar with Cayetano versus Monsud. I think this is about practice of law. Who is a lawyer in the practice of law. Now, given the criticisms on the Supreme Court's credibility and members' competence, I think he was referring to I do not know. This is I do not know what his point in asking this question. But the question is, given the criticisms on the SC's credibility and members' competence, would you consider revisiting Cayetano versus Monsud? Do you agree with the premise? The premise is, given the criticisms on the SC's credibility and members' competence. Do you agree with that premise? Because if you do not agree with that premise, then you do not need to answer the question.
Your Honor, the immutability...
What did you say, Your Honor? You are recording my vote?
The immutability principle says that after finality, the court divests itself of jurisdiction over the case. And no court, not even the Supreme Court, can revive that decision. That decision is already entombed. So wala na tayong magagawa riyan. It may be an erroneous decision. For as long as there was jurisdiction over the case, then that decision will remain as it is.
Jurisdiction, or probably when the judgment is void.
Yeah.
You will agree with me?
Yeah, if
And
the judgment is void.
If the judgment is void and there is a question of jurisdiction, then you may allow a revisit of that decision. On that note, Justice Art, I am through.
Marami pong salamat. Marami pong salamat sa inyo lahat.
Thank you, sir. Liton Hua. Dr. Liton Hua.
Your Honors, the next to be interviewed is Commissioner Rene V. Sarmiento of the Commission on Elections and Professor San Beda Law College.
Yeah. Oh, here comes another friend. Welcome, Rene. You prefer to be standing? Okay.
Mawalang galang po sa miyembro ng JBC. Kung ako po ay papayagan niyo po, nais ko po magsalita sa wikang Pilipino. Dahil marami pong nakikinig po mula Tawi-Tawi hanggang Batanes, Catanduanes, Zambales, Kabikulan po at Cebu. At ito po ay sinusubaybayan po nilang lahat sa radyo at television.
Tama ba yung obserbasyon ni Justice Bron na maganda ito dahil naralaman lahat ng buong bayan kung anong proseso, no?
Opo, yan po ang reklamo po ng mga tao na hindi naintindihan po yung pinag-uusapan po sa proseso ito.
Dapat sa mga candidates sa Commission and sa COMELEC, ganun doon ang gagawin dapat, ano?
Maganda po mungkahi yan, Justice Peralta.
Okay,
Kung papayagan niyo po, nais ko pong sa loob ng 5 minuto po, ay aking talakayin po. Ano ba ang panuntunan ko para po ipataw, itaguyod ang katarungan or judicial philosophy? Ano po yung vision at mission ko po at paano po ito po ay mapapatupad or work program? In 5 minutes po kung
pwedeng gawin 3 minutes.
Sige po. Sige po.
Okay. Thank you. You go ahead.
So,
Commissioner.
ang unang tanong po, miyembro po ng JBC, ano po ba ang panuntunan ko para po itaguyod ang katarungan sa ating bansa? Ano ba ang aking vision at mission? At ano po ang kaparaanan para ito po ay ipagpatupad? Ang aking pong panuntunang para po ipagtaguyod at ipataw po ang katarungan or judicial philosophy ay nasa loob po ng 2 konsepto. Ito po ay malapit sa puso ng mga Pilipino. Ito po ang tinatawag na karapatang panlipunan or social justice at karapatang pantao or human rights. Ang karapatang panlipunan po ay wala pong definisyon sa ating saligang batas. Pero po ayon po sa pag-uusap namin sa Constitutional Commission na kung saan ako po ay naging bahagi, ito po ay isang material at social na infrastruktura para po ipagtaguyod ang karapatang pantao at para po matumingkad po ang tinatawag na dignidad ng tao at magkaroon po ng democratic participation sa ating lipunan. Ang isang pong miyembro ng hukuman na nagbigay po ng paliwanag kung anong konseptong ito ay si Justice Laurel sa kasong Kalalang versus Williams na ang sabi niya, ang social justice ay isang kaparaanan para mapadama sa taong bayan ang isang batas na nakikiramdam at nagtataguyod ng pangkalahatang promotion of the general welfare. At ang sabi niya, ang pagkapantay-pantay ng social and economic forces para maabot po o makamit ang katarungan. Yan po ang sabi po ni Justice Laurel. Yung ating karapatang pantao po, Justice Peralta at miyembro ng JBC, ay hindi rin po nabigyan ng definisyon sa ating konstitusyon. Pero po, ang pagkakaintindi po nito, ito po ay mga pribileyo, mga karapatang pantao na angkin ng kababaihan at kalalakihan at sumusunod po sa prinsipyong hindi mahiwa-hiwalay at universal, principles of indivisibility, interdependence, and universality. At dahil po tayo ay ginawa sa imahen ng Diyos. So, paano ko po makakamit po ito? Lalong-lalo na at bilang dagdag po, miyembro ng JBC, ano po ang vision at mission ko po, maliban sa judicial philosophy? Isa pong hudikatura na etiko, may moralidad, at may katapatan sa rule of law, at ang nagtataguyod po ng promotion of the common good. Na ang naglalayon po na maabot po ang maliliit na ating kababayan na iniitsapwera po. At wala pong pagkakataon na magkaroon ng pantay-pantay sa tinatawag na rule of law. Now, how to achieve this is the question. Nandyan po ang pagbalabalanse o tamang timpla ng tinatawag na judicial activism at judicial restraint. Ang tamang timpla o pagbabalanse ng tinatawag na strict construction or loose construction. Ano po yung tinatawag na judicial restraint? Sabi po ni Justice Oliver Wendell Holmes, ibig sabihin dahan-dahan sa pagbabago ng mga batas, pagrespeto sa mga past court decisions, at pagbigalang sa lehislatura, sabi ni Justice Oliver Wendell Holmes. Ang judicial activism naman po, ibig sabihin po bukas sa mga nangyayari sa lipunan, bukas sa pulso ng sambayanan. Strict construction po, sabi po ni Thomas Jefferson, ibig sabihin po kung ano ang sinasabi ng teksto ng konstitusyon ay dapat sundin. Sabi naman ng unang at greatest justice of the U.S. Supreme Court, si John Marshall, sa kanyang loose construction, dapat ang konstitusyon ay nakikinig sa pulso ng bayan. Nakikinig po sa call or signs of the times. So, ano po ang tamang balanse sa judicial restraint, judicial activism? Strict construction o loose construction? Ang sagot po ang tinatawag na mapanlikhang hudikatura, judicial creativity, na binabalanse po ang tradition, progress, and development. Isang magandang halimbawa po na miyembro ng hukuman na nagtaguyod po ng judicial creativity ang dating punong hukom ng Korte Suprema, si Roberto Concepcion. Sa dalawang kaso po, Lansang versus Garcia at kasang Stonehill versus Jokno, siya po ay mapanlikha ang nagkaroon po ng mga bagong desisyon na hanggang po ay tinatangkilik ng mga estudyante, ng mga hukuman ng ating bansa. Ngayon, ano po yung work program ko po para mapatupad itong tinatawag na judicial philosophy at itong vision and mission? Una-una po yung expansion. Pagpalawak po sa Section 5, Paragraph 5 of Article 10 of the 87 Constitution. Una-una po ang pag-issue po ng mga bagong writs. Halimbawa po, dagdag sa writ of amparo, writ of habeas data, writ of kalikasan, ay writ of salvation, writ of paglalansag, at writ of hoviness. Ano po yung writ of paglalansag? Nasa saligang batas po natin, pag hindi po authorized ng mga private armies, they should be dismantled. So, ibig sabihin, through this writ of paglalansag, itong private armies nagbibigay sakit ng ulo sa ating Pilipino ay will be dismantled. Ano po itong writ of salvation? Marami po tayong mga kababayan na nasa loob ng piitan. Kung sila po ay may karamdaman, ay may sakit, you can resort to writ of salvation para po maasikaso po ng mga doktor. Writ of hoviness, mayroon po tayong mga kabataan na nandun po sa mga piitan din po, nagtatrabaho po sa mga factory. So, kung sila po ay may karapatan na hindi po sinusunod, they can avail of this writ of hoviness para po masagot po sila. At panghuli po ang Magna Carta for those behind bars. Marami po nasa piitan, and through this Magna Carta of people behind bars, ang kanilang pong pangangailangan ay matutugunan. And finally, the creation of special human rights courts. Dumadami po ang mga kaso na hindi po nare-resolve dahil po sa mga kasong human rights cases. If we create a special human rights court, ito po ang paraan para po lumuwag ang docket po ng mga hukuman po natin. Ang pangalawa po, kagalang na hukom at miyembro ng JBC ay ang tungkol po sa enhancing communication with the public in the spirit of transparency. Ang nauna ko pong suhestyon, ang steps of the Supreme Court, dialogue with the public and the media. So ito po isang kaparaanan na pwede pong gawin po.
Pasensya ka na lang, Commissioner, ano? Yung, kasi mayroon pa kami kasing isa.
Opo,
Seryo,
opo.
okay.
Opo.
So, ang una magtatanong po ay si Attorney Cayosa.
Magandang hapon, ma'am.
Magandang hapon
Komportable
po.
ho ba kayo nakatayo? Komportable po kayo
Komportable po.
nakatayo? Kahit naabot na isang oras, mahigit?
Opo,
Okay, sige
opo.
po, sige po.
Salamat po, Mr. Chairman. Paumanin niyo na po. I will have to speak in English
Opo.
and feel free to respond in Filipino if you
Opo.
so wish. If we were to continue the presentation that you made, I believe you presented this before the IBP during the forum. You did not get to the part where you would propose knowledge and technical sharing on best judicial practices. Would you care to elaborate what you mean by this? And I was thinking in terms of peer sharing among the judges. But I would like to find out what your thoughts are on this.
Opo. Ito po ay magandang programa ng Korte Suprema. Dahil una-una po ito po ay isinasagawa ng Komisyon, COMELEC, na kung saan po ako ay nanunungkulan yung sharing of best election practices. Ako po ay dumalo sa mga komperensya na kung saan natuto po tayo sa kanila at sila sa atin. Halimbawa po, yung pagkakaroon ng satellite registration sa mga malls. Noong 2011, more than 38 malls ang ginawang registration center po for PWDs, persons with disabilities. Sa ibang bansa, this is a best or good election practice. Natuto po sa atin. Pangalawa po, nandiyan po yung pagkakatayo ng interagency and NGO network to empower PWDs, to empower IPs, to empower detainees. Wala po sa ibang bansa na isang electoral commission na kung saan po may interagency where NGOs and government are working together. So, sa hukuman po, kung ako po ay maging punong hukom, magkakaroon po ng sharing of best practice. For instance po sa India, may tinatawag na epistolary jurisdiction sa India po. Ang pasimuno po ay Chief Justice Bhagwati ng India. Ibig sabihin sa sulat lang po, kung isa po ay isang mahirap, walang kakayan kumuha ng abogado, isang sulat, the Supreme Court will entertain this epistle or letter or complaint from isang manggagawa, isang magsasaka, o isang mahirap. So, best judicial practice na pwedeng matutunan po natin. Sa Estados Unidos po, nag-create po ng judicial conference si Chief Justice Staff noon, na kung saan pulong po ng mga magistrado ng Korte Suprema, appellate courts, and yearly, they share their experiences, lessons from one another. So ito po ay pwede pong gawin po natin sa ating bansa para po lalong umunlad po ang pagre-resolve ng ating mga kaso.
Maraming salamat uli. Dalawang tanong na lang po. What is your concept of restorative justice, and would you extend the application of restorative justice to adult offenders?
Ako po ay may prison advocacy. Ako po ang pangulo ng PRESO. PRESO meaning Prison Rehabilitation Empowerment Service Organization. Ito po ay binubuo po ng mga madre, kaparian, mga miyembro ng NGOs at retired members of the judiciary. Ako po ay pabor sa restorative justice, na sa halip na kaparusahan, maghanap po ng kaparaanan to rehabilitate a convict, a person. Hindi po parusa. Dahil po ang tao ay magandang kalidad with qualities, so by restoring his dignity to restorative justice, magiging productive member po siya ng ating lipunan. And in this kind of justice, the community po is involved to restore the dignity of that person. Ako po ay pabor po sa ganitong hustisya sa ating lipunan.
Would you go so far as to indicating in the judgment where the offender is found guilty to require him to undergo counseling or rehabilitation as part of the decision?
Ako po ay sang-ayon po sa mungkahingan na maging bahagi ng ating mga desisyon ang counseling services, because when we counsel, we inspire people. Lalong bumabalik ang kalang tiwala sa sarili at kalang dignidad. So I think this should part of the judgment to counsel and inspire the convicts.
My last question.
Opo.
Were there instances in your public career where your independence or integrity was put to test, and when you had to decide or rule in conflict with the interests of an appointing authority?
Ilang beses po ako na nagdesisyon po sa COMELEC. I can cite 6 or 7 cases. Ako po ay dissenting opinion. Halimbawa po ang kaso ng Ladlad, Liberal Party versus COMELEC, Amora versus COMELEC, Panlaki versus COMELEC, at ilan pa ho. Pwede kong banggitin po yung kaso ng Mendoza versus Pagdanganan. Ang kaso po ng sa Pampanga involving Governor Panlilio. And in all these cases, I was sustained by the Supreme Court. Though I was the dissenter in these cases, pagdating po sa Korte Suprema, binanggit po ang pangalan ko and I was sustained, affirmed by the Supreme Court in these cases. And if I may add, Your Honor, please, sa kaso po ng Anggaling Pinoy. Ako po ay hinirang ng ating Pangulong GMA. But I voted against the nominee of Anggaling Pinoy, si Kinatawan Mikey Arroyo, knowing and believing that he could not well represent the security guards. Ako po ay dissenting opinion po sa kaso niyan. So in all these cases, I have maintained my independence to ensure the integrity and, of course, the independence of the Constitutional Commission like the COMELEC.
Thank you, Mr. Commissioner. Good luck.
Salamat po.
Thank you, Mr. Chairman.
Attorney Mejia, please.
Thank you, Justice Peralta. Magandang hapon po, Commissioner Sarmiento.
Magandang hapon po.
Sasamantalahin ko po yung pagkakataong ito na nagkaroon ng isang kandidato o aplikante na kasapi ng nagbalangkas ng ating 1987 Constitution. Kasi po may mga katanungan at batid naman ninyo ito na may kinalaman katulad sa JBC, yun pong nakalipas na pasya ng ating Korte Suprema tungkol po sa bilang ng kailangan bilang ng pagiging kasapi ng JBC. Ano pong bilang pong miyembro ng Constitutional Commission, ano po ang palagay ninyo rito?
Una-una po, ginagalang ko po ang naging kapasyahan ng ating hukuman tungkol po sa isyung ito, although may pending motion for reconsideration. Kung po'y tatanungin nyo at batay po sa aking memorya, sa aming diskusyon sa Constitutional Commission of 1986. Initially, ang gusto po ng Commission ay unicameral legislature. As a matter of fact, ako po, si Christian Monsod, ay nag-sponsor po ng resolution providing for a unicameral legislature. Pero po sa botohan po sa plenary session ng CONCON, natalo po ng isang boto. Yung unicameral, naging bicameral. Kaya nga po, sa tingin ko po, yung isang botong yun ay para sa unicameral. At dahil po ang ating saligang batas provides for bicameral legislature, para sa akin po, tama lang na kada house ay mayroon pong kinatawan sa JBC.
Ganon din po ba dun sa pagsususog sa saligang batas?
Ako din po ay sang-ayon din po, Ginoong Attorney Mejia, na tungkol po sa amendments to the Constitution, na isa pong issue po ngayon, dahil may mga advocates po for charter change. So kung ito po ay maipagpatuloy, tulad ng amending the economic provisions of the Constitution, solely the economic provisions, ano po yung proseso ng amendment? Ako po, ang sa tingin ko po, we follow the process of each house voting 3/4 independently. Yung 3/4 lang po na referring to the Congress as a whole, because our thinking at the time, it was unicameral legislature. But there were supervening events. At ang nangyari po dahil sa isang boto, nanalo ang bicameral. Kaya tama lang po, na ang botohan po ay 3/4 sa House, 3/4 din po sa Senado.
Salamat po. Kaugnay pa rin po sa ibang mga probisyon ng saligang batas. Batid naman po natin na may mga probisyon na nahihimbing o natutulog at hindi na isa sa katuparan. Pangunahin po dito yung pagbawal po sa mga political dynasties. Sa palagay po ba ninyo, kapag kayo naging Chief Justice, mayroon po kayong magagawa tungkol dito?
Okay. Ang provision na yan ay sponsored po ni Commissioner Liedo. Kasama po ako. To democratize access to political opportunities, dapat po ipagbawal po ang political dynasty. Now, there will bills introduced in Congress, pero ito po ay frozen, nasa back burner po. Ilang attempts po, kasama po ang Senador Miriam Defensor Santiago, Senator Teofisto Ginggona, Senator Tanyada, pero ito po ay hindi na isa kutuparan. So, kung ako po ay uupo, okay, by God's will sa Korte Suprema, ako po ay gagawa ng paraan na magkaroon po ng buhay ang constitutional provision po ito.
Ayon po kay dating Chief Justice Panganiban, isa daw sa pamantayan ng isang mahusay na Chief Justice ay kailangan ni kanya ay isang passionate reformer. Kung tama po yung pagsasalin ko, masigasig na tagapagpabago. Palagay po ba ninyo, kayo po ay akma sa pamantayang ito?
Sa tingin ko po, ako po ay, humbly speaking, ay akma kung pag-uusapan po ang pagbabago. Una-una ako po ay naging miyembro ng Constitutional Commission of 1986. Ano po yung mga pagbabago na aming na-introduce sa ating saligang batas? Creation of the Commission on Human Rights. Isa po tayo sa mga bansa na nanguna sa pagbuo ng Commission on Human Rights. Diyan po sa Bill of Rights, na diyan po ang Independent and Competent Counsel during custodial investigation na aking naibahagi sa Constitutional Commission at naaprubahan. Nandyan po ang anti-torture and indemnification of victims of torture, which was approved by the Constitutional Commission and part of the Bill of Rights. At nandyan po yung legal assistance to the underprivileged. Isa pong proposal ko, adopted by the Constitution, nasa Bill of Rights po and Article of Judiciary, at panghuli po ang Judicial and Bar Council. Isa pa ako sumuporta na magkaroon po ng Judicial and Bar Council sa po Commission on Appointments. At natadagdag ko po, kailangan na Attorney Mejia, sa COMELEC, ako po ay nakaupo bilang commissioner. Ano po ang mga pagbabago po dyan? We have created in the COMELEC an interagency, an NGO network to empower detainees. For the first time in our history, in 2010, more than 17,000 detainees voted from the start of our republic. 2010 October, 15,000 po ang bumoto sa barangay elections at may isang nanalong barangay chairman po, isang detainee sa Bai, Pangasinan. Interagency and NGO network to empower persons with disabilities. For the first time tayo po nagkaroon ng satellite registration sa 38 shopping malls. And this is a first, a good election practice recognized around the world. And we have approved a resolution na sa darating na 2013, accessible polling stations po sa may kapansanan, sa matatanda, sa pregnant women. Hindi na po aakyat sa second floor at third floor. Bagkus po sila po ay boboto sa baba. And finally, we have indigenous peoples, 16 million of them throughout the country. Ito po ang Mangyan, Ita, Negrito. Taningin mo sila, anong pangalan mo? Medicol, Kortal. Kailan kaping na tag-ulan, Singkamas, Tagmanga. Ito po ang sitwasyon po nila. We have created an interagency, an NGO network to empower indigenous peoples. Kung walang identification card, on the basis of a certificate of confirmation issued by the National Commission on Indigenous Peoples, sila po ay pwede magparehistro at pumoto. And of course, automation, which I supported before 2010 elections. So ito po ang mga pagbabago nagpapakitang ako po ay passionate for reforms at pagbabago sa ating lipunan.
Hindi naman po siguro lingid sa inyong kaalaman na mayroong pagtutol sa inyong paghirang no, bilang Chief Justice. At kabilang na rin hinahanap ko po kanina, kaya lang mukhang hindi ko po nadala, pero kung natatandaan ko, ang pagtutol po na ito, pangunahin dito ay galing kay Congressman Maliksi at kay Senator Cayetano. No? Maaari po bang bigyan nyo kaming paglilinaw kung ano po ang kung tungkol po saan ito at ano po ang posisyon nyo rito?
Ito po ay tungkol una-una yung reklamo po ni Congressman Maliksi. Ito po ay protesta ng isang alkaldeng natalo, si Sakilayan sa Imus, Cavite. Siya po sa eleksyon ay nanalo po ng walang more than 8,000 votes. Pero po sa protesta na inihain po ng kanyang kalaban si Maliksi na without resorting po sa picture images na sinasabi po ng ating resolusyon based on manual recount and ignoring the plea of Mr. Sakilay, nagdesisyon po ang RTC of Cavite in favor of Sakilayan. Yung 8,000 na wala po. And to think that this is automation. Based on manual recount, not on the rules on automation that we have adopted to resolve electoral protest. So, umakyat po si Sakilayan sa COMELEC. Ako po ang presiding commissioner ng COMELEC. So, sabi ko, we issue a TRO para po hindi makaupo while resolving this case on the merits or this special petition for certiorari. Dahil ako po ay naniniwala na collective po ang aming desisyon, 3 pong pangalan ang nakalagay po sa order. Ako po at 2 miyembro ng komisyon. So pinirmahan ko po yon for the issuance of a TRO. Nag-descend po yung 2 kasama ko. Ngayon, in the spirit of transparency, because of a heated political climate in that place, ako po yung nag-order. Ilabas po natin ito, malaman ng public. I've been always for transparency, Your Honor, please. At dahil po dyan, nagreklamo po si Congressman Maliksi, bakit pinalabas ko po. Pero wala pang rules na prohibiting me as the presiding commissioner of the COMELEC. And again, in the spirit of transparency, dapat malaman ng taong bayan. That evening, may isa pong interview sa television at ako po ay tinanong. Para po maging malinaw, sinabi ko po sa television at alam ko nakikinig po si Mr. Sakilayan. Mr. Sakilayan, wala pong TRO. Dahil ako po bumoto, but I was overruled. Ako po ay outvoted ng 2, wala pang TRO. And the following day, I issued another order setting the case for hearing para ipakitang walang TRO na in-issue po ng COMELEC. So not in our rules, Your Honor, forbidding me to release this order. I want for people to know ano po ang katotohanan at boto. Doon po naman po sa kaso po ng Tinga versus Cayetano, ito po yung dati pong nakahain po sa 2nd Division. Ngunit dahil po pina-inhibit po yung mga miyembro ng 2nd Division, at dahil po may tiwala sa 1st Division na kung saan ako po ang presiding officer, believing in our fairness and impartiality, ito po ay nalipat po sa amin on the motion filed by Mrs. Cayetano. I filed a comment, Your Honor, please, attaching these motions to show that it was transferred to us believing in the independence and impartiality of the 1st Division. Kino-question po ang aking independence and probity and competence dahil po sa kasong ito. But this would only show a testament regarding my independence, my probity, and competence. Your Honor, please, the case was transferred to us April 2011. My last order was July 17, 2012. Na kung hindi po pwedeng i-retrieve, why not decrypt yung photo image po? 13 orders were already issued from April 11 up to July 17, 2012. No question about my independence. No motion assailing my integrity as the presiding commissioner of that 1st Division. 13 orders, Your Honor, please. Ngayon, nung na po sa objection, ako daw po ay napasama sa fraud sa 2007 and 2010. Mismo po ang chairman ng COMELEC na si Chairman Sixto Brillantes na aming iginagalang po. Mismong si Secretary of Justice Laila de Lima na at that time abogado po ng oposisyon ang sinabing wala akong kinalaman sa fraud na nangyari po noong 2007. Sumulat po ang Ambassador Tita de Villa ng PPCRV the other day submitted to the JBC and saying that since 2007, 2008, 2009, and up to registrations arm, kanya po nakita ang aking performance, upholding integrity and honesty. At wala pong reklamo po na NAMFREL o PPCRV, Diocese of Marawi, kung ano paman, tungkol po sa pagpapatakbo ng halalan po doon. As a matter of fact, Your Honor, please, in 2010, the Islamic Electoral Reform Movement ay binigyan po yung abang lingkod, recognition for upholding the integrity of elections. Of course, it was not perfect. No elections are perfect. It's a big management problem or headache ang election. But I've done my best, my very best, to uphold integrity of the electoral process.
Salamat po, yun na po yung huling katanungan ko. Thank you, Justice Peralta. Good luck po.
Justice Lagman, please.
Magandang hapon po.
Ma'am, magandang
Commissioner
hapon po.
Sarmiento.
Magandang hapon po, ma'am.
Ako ay matamang nakinig ng inyong pangunahing pananalita.
Salamat po.
At ako'y nasiyahan dahil nailahad nyo ng malinaw at buong buo ang inyong mga binabalak gawin kung kayo ay matatalaga bilang punong maestrado ng ating kataas-taasang hukuman.
Salamat po, ma'am.
Nailahad nyo ng malinaw ang larawan, ang magiging larawan ng ating hukuman kung kayo ang magiging ulo ng hudikatura. Meron akong mga inihandang mga katanungan, ngunit yon ay nasagot na ng malinaw sa pagtatanong ng aking mga kasamahan. Kaya palagay ko dahil hindi ko na kailangang sayangin pa ang inyong oras at wala na akong itatanong. I just want to wish you good luck.
Salamat po, ma'am.
Thank you.
Salamat po.
Justice Sermo si Maden, sir.
Good
Magandang hapon po,
afternoon,
Justice po. Magandang hapon po.
Attorney Sarmiento and I were confirmed together at the Commission on Appointments. Attorney Sarmiento, Commissioner Sarmiento has been made famous and popular as a commissioner of the commission elections.
Maraming salamat po,
Now,
Justice.
you do not propose to write your decisions in Filipino.
Mayroon pong isang huwes, si Judge Gatbaitan, no? Nagsusulat po ng Tagalog, wikang Pilipino. Sa Bulacan, may isang huwes, nagsusulat po ng wikang Pilipino. But it will take a long time, ano po, na sumulat sa wikang Pilipino. But baka pwedeng pag-usapan po sa Korte Suprema, mas maraming makakaintindi po kung
I
ano po
wonder
ang
if that
desisyon.
will be published in the Supreme Court reports annotated.
Malaki pong adjustment po sa atin, pwedeng umpisahan po.
Will you write your decisions in English? As Chief Justice, not in Filipino. Do you believe that there are many provisions in the Constitution, 1987 Constitution, which you helped approve, that need amendments or revision?
Opo, kagalang-galang na hukom, Justice
Do you
Hermosissima.
agree to the
Opo.
convening of a constituent assembly to amend the Constitution instead of a constitutional convention?
Justice Hermosissima, I'm in favor of the Constituent Assembly as a mode of amending the Constitution. From 1789 up to the present, the U.S. Constitution was amended 27 times. In the process, Your Honor, please, was through Congress. No constitutional convention was convened in the entire history of the USA to amend the U.S. Constitution 27 times, though there were 11,000 proposed amendments to the U.S. Constitution, and the process was two-thirds of its House voting and then presenting to the state for ratification. So
All
ito
right,
po ang-
in the Constituent Assembly that is being proposed, with the Senate and the House, will they be voting together, separately or jointly?
Mr. Justice, you have to vote separately because kung jointly po, matatalo po ang Senado. I will follow the formula being proposed by my good friend and colleague in the Commission,
What is the statement?
Berna's formula.
What is the statement in the Constitution
Opo.
which you framed?
Constitution po, kung
Separately or jointly?
ang intindi po namin yan po sa Constitution as written textually, mukhang buo. Hindi po malinaw po no, ang ating Constitution tungkol sa amendment. Again, Mr. Justice, because of the issue of unicameral and bicameral, I think, in all honesty, it was overlooked by the Constitutional Commission, by the Committee on Style, kung bakit hindi po ito nalinaw.
So that's another provision that has been overlooked.
I think so, Mr. Justice, in all honesty and humility.
So what do you say? Separately or jointly?
It should be separately.
Separately.
Each house voting separately.
What do you say to the proposition of Father Bernas? That
It's a good-
that the House first approves certain provisions of the Constitution, amendments, and then it's brought up to the Senate for approval, for confirmation.
It is a good proposition from
Of course,
Father Bernas.
that should be approved by the people as a whole.
Totoo po yan for ratification by the people as a whole. Yan po ang tinatawag po, Justice Hermosillo, the Bernas formula, the Bernas mode of amending the Constitution. Ako po ay bukas at sangayon po sa kanyang proposisyon na ang kaparaanan po ay mangunguna ang mababang kapulungan at susunod po ang Senado.
Would you agree to a charter amendment that would allow the sale of Philippine lands to foreigners as opposed to the Krivenko doctrine?
Your Honor, please, sa ngayon po may mga proposals po to amend the economic provisions of the Constitution. Ako po ay bukas po dyan dahil nga po sa era of globalization. At batay po sa karanasan ng maraming bansa, binubuksan po ang kanilang ekonomiya. Yung 60-40 sharing formula or equity principle ay mukhang outmoded na po. At dapat buksan po ito para yung mga restrictions po sa ating saligang batas on economic provisions ay mabuksan. At tayo po ay makasama po sa mga bansang nangunguna po sa atin. That's why ako po ay sumasang-ayon na mag-usap po ang Senado, Kongreso at ang ating Pangulo para po pag-isipan po ang pagbabago ng ating saligang batas strictly on the economic provisions.
I went to Beijing some time ago, and there, since it's a communist country, no private individual is allowed to own lands. But yet, I could see several structures, hotels, and other buildings constructed by private individuals or private corporations. And so I asked them, why, how come? How did these people construct buildings which will last for years? The answer was they would lease the land for 99 years. Well, it's just like sale. Well, so you agree to the abolition of the 60-40 proposition?
Not necessarily po, Justice, na completely abolition of the 60-40 equity formula. Marahil po pwedeng dagdagan po. Pwede pong 80-20. Kumbaga, 60-40, medyo taasan po yung equity po.
The idea is to bring investments to
bring investments, Your Honor, please, baka pwede pong 50-50. Isa po magandang formula po yan. Isang 50-50. This will attract investments and based on studies po, those with relaxed economic provisions in their constitution.
Do you agree to the amendments on the mining laws just recently proposed by the President?
Mainit po ang pagdedebate tungkol po sa mining laws, no? Pero ko po ay bukas if it will bring more investments to our country, provided properly regulated and with strict laws on enforcement. Kung ito po ay magpapaganda ng hanapbuhay ng bawat Pilipino, bakit hindi po? Kagalang-galang na ako.
Now, I suppose your forte is election laws.
Ako, hindi lang po election law, Justice Hermosissima. I worked for 9 years in the office of Senator Jokno. I was involved in the private practice of law for 26 years before
Have
I
you
joined
been a
Congress.
litigation lawyer then?
Opo. Yes, Your Honor, please. Handling criminal, civil, and labor cases.
So you realize that the Supreme Court is a court of general jurisdiction. And so If a case is assigned to you and it's not your forte, you cannot refuse.
Kaso po sa Regional Trial Court,
No, in Supreme Court.
yes, Your Honor, please. Well,
You're
it cannot,
applying,
of course.
You're applying for Chief
Yes, Your Honor.
Justice. Sorry, you forget that.
Thank you, Mr. Judge. Totoo po na talagang hindi na pwedeng reviewin po ng hukuman yung decision pong ito. That's why po a justice should be very careful in ruling on cases pending before it, because it is the highest tribunal. It is the Supreme Court, and we have to bow and respect decisions of the Supreme Court.
Have you tried cases involving criminal law, complicated civil cases?
Your Honor, please, many of these cases
Administrative
are
law.
now in the Supreme Court, cases that have handled while in the office of Senator Diokno, and cases I handled on my own after the death of Senator Diokno. And several of these cases are now in DESCRA.
So you have handled cases on appeal,
On appeal,
not only
opo.
to the Court of Appeals but also to the Supreme Court.
Opo. The case of Nolasco versus Panyo on search warrants, the case of Surya versus Pineda on right to education that was decided by the Court of Appeals, and other several cases, Your Honor, I've handled and are now found in DESCRA and being studied by law students.
Well, let's go back to my first question. You do not propose that decisions as Chief Justice will be in Filipino.
Not at this time po, Justice Hermosissima. Mukhang hindi po handa ang ating bansa at
I
ating
was
mga
wondering
kababayan.
because all the while you have been talking in Filipino.
But I would favor at this time po opinions written in English or ponencias, but gradually po.
In the decisions that you write for the COMELEC, were these decisions in English or in
These were decisions,
Filipino?
Your Honor, please, written in English.
Oh,
Well, of course, in these proceedings, it's really for show because the whole country will be listening to you.
that's all, sir. Okay.
Salamat po.
Secretary Mosngi.
Thank you, Mr. Chairman. I have no further questions. I'm sufficiently enlightened by the answers of the aspirant.
Kaibigan ko si Commissioner Rene. He used to appear before me sa RTC eh. Tsaka sa Sandigan Bayan eh. Oh.
If I may add, Your Honor, please, I appear before Judge Valderrama,
Yeah,
Judge
yeah, I know.
Mendoza,
I
Judge
know.
Peralta,
Yeah.
Judge
Even-
Rosamin,
Yeah.
sa RTC po.
You haven't changed yet. You're still the humble practitioner that we know.
Maraming salamat po, Justice.
Eh, ang tanong ko lang ho dati nag-apply ka sa sa justice lang ng Korte Suprema eh. Hindi ho ba?
Totoo po yan. Kagalang-galang na hukom.
Eh bakit ngayon nag-apply ka ng Chief Justice, Commissioner Rene?
Una-una po, Justice Peralta, ako po ay na-shortlist. Hindi na po ako na-appoint na member ng Supreme Court as an Associate Justice. So ito po ay isang malaking pagkakataon po para sa akin, para magsilbi po sa ating bansa. So I think to be a Chief Magistrate or Chief Justice is not only a visionary, but also a leader and CEO, an all-out, all-season public servant. So I think this is now the opportunity for you to introduce changes in the judiciary.
Kasi may reservations kasi dati eh. Naalala ko, nung nag-apply kang Justice ng Korte Suprema, galing sa isang Assistant Commissioner, may mga views nun na dapat ata pumunta muna sa Court of Appeals bago pumunta rito sa Korte Suprema. Kasi tradition, yung mga nanggagaling sa COMELEC, papunta sa Supreme Court as Associate Justice, mga chairpersons yun eh. Si Justice Pardo, chairman ng COMELEC. Tanong nun, paano yung Assistant Commissioner, diretso sa Korte Suprema, Associate Justice? Sabi nila, dapat dadaan mo na sa Court of Appeals. Kaya tinanong ko, Assistant Commissioner, probably iniisip mo, Baka siswertein ka ngayon. Dati hindi ka sinwerte sa Associate Justice. Kaya Chief Justice na ang inambisyonan mo nun. Ngayon,
Kagalang na Justice Peralta, ako po ay nagkaroon ng isang refleksyon. And since 1986, I've been in government as member of the CONCON. Ako po ay nagsilbi po sa Presidential Human Rights Committee, kasama po si Justice J.B.L. Reyes. Ako po ay nagsilbi po sa Select Committee to screen judges and justices. Ang aming pong pinuno ay si Secretary Neptali Gonzales, kasama po si Undersecretary Renato Puno, at kasama po si Solicitor General Cedfrey Ordonez. Ako po ay nagsilbi sa Office of the Presidential Advisor on the Peace Process. Ako po ay naging chairman ng negotiating panel dealing with the CPP in Norway and Netherlands, and also dealing with the Muslim insurgents in the South.
kasama mo ato dati si Justice Tess de Castro, hindi ba?
Kasama ko po, dalawa po sa miyembro ng hukuman, ang kasama ko sa peace process sa Netherlands and Norway, Justice Brion was our consultant on labor. Kasama ko po sa Norway. Justice Tess de Castro ay kasama ko for many years in the peace process. Siya po ay nasa Department of Justice and work with us in the peace process.
Sa OSG, sino kasama mo nun sa OSG?
Kasama ko po ang Soldier Bebot Delio na aming naging pinuno sa peace panel negotiating with the CPP and PA.
Ito gusto ko lang tanungin kasi nagkakaproblema kami sa HRED tungkol sa mga party list, hindi ba?
Opo.
Yung mga questions of nominations on party list, dinadala sa dinadala sa COMELEC, hindi ba? Kayo may jurisdiction.
Opo.
Kung into ba, maging candidate ng party list o hindi, di ba? Pinagsasubmit nyo ng evidence, lahat-lahat. Then, i-decide nyo based on the totality of the evidence, pwedeng kandidato ito. Hindi ho ba? So,
tama po.
Party list, election, nakakuha sila ng nominee. Hindi ho ba?
Totoo po.
Pagkakuha ng nominee, na-elect na yung party list, nag-oath na as member of Congress as a nominee, pagtapos, nagpapile sila sa HRED ng kaso. Pinapadisqualify. Using the same grounds, doon sa COMELEC, which you have already resolved. Ang tanong ko ganito hindi ba meron overlapping of jurisdiction? Kasi nakalagay kasi sa, I think you read that case of Lim Kay Chong, Pagsabi, pag ang congressman has taken his oath as member of Congress, so any question as to his qualifications, jurisdiction is HRED. Hindi ba? So, ang ginagawa nila, using the same arguments doon sa COMELEC, dahil yun ang pinal-interpretation sa COMELEC, disqualification din to be a nominee Ngayon, mag-take out na ngayon, file a disqualification, co-warranto doon sa amin at hindi he should be disqualified. Tama ho ba yung observation mo
Maganda
gano'n?
po ang observation ni Justice Peralta. Following a long line of decisions once proclaimed, ousted po ng jurisdiction ng COMELEC, pupunta po sa HRED. I think isa po itong issue na dapat pag-aralan po ng Korte Suprema. Now, using Section 5, Paragraph 5, Section 10 promulgates rules relating to enforcement of constitutional rights, pleading, practice, and procedure in courts of law, admission to the bar, and legal assistance of the underprivileged.
No.
Magandang tingin po ito, kagalang-galang na.
You're referring to Paragraph 5 of Section 5
Opo.
of Article. Nagpapasalamat nga kami sa mga members ng constitutional body dahil sinama yung protection and enforcement of constitutional rights na meron kaming power of we have na rule-making power, di ba?
Totoo
Kaya
po.
lumabas yung sinasabi mong writ of amparo writ of
Kalikasan, writ of habeas data.
Ngayon gusto ko pang dagdagan, writ of salvation. Akala ko yung writ of salvation na proposal mo ay babae yun. Salvation
Salvation
hindi
po.
ba? Okay. Isang tanong ko doon sa Article 12, Paragraph 1, yan ang basis kasi na sinasabi nila naging aggressive na masyado ang Korte Suprema, hindi ba? Yung grave abuse of discretion, kahit na political issues daw, to a certain extent, rinirasolve na ng Supreme Court, should be only, we are not supposed to encroach on political issue, Now, ang tanong doon kasama ka ba doon sa nag-propose doon sa Constitutional Convention?
Your Honor, please, it was a proposal made by Chief Justice Roberto Concepcion, expanding the meaning of judicial power.
Yeah.
And since we respect the esteemed retired Chief Justice at that time, based on his experience in credentials and expertise, we respected his proposal and it was adopted.
I think, gusto niya marahil, use the Supreme Court to check abuses of the executive and the legislative. Probably, I think that was his purpose.
Ang paliwanag po ni Chief Justice Roberto Concepcion, it does not totally erode the political question doctrine, but simply limits political question doctrine. So, nandyan pa rin po yung political question. Medyo may limitasyon lang po. Batay po sa karanasan na naging kasamahan niyo po sa Korte Suprema.
Ngunit, maganda pa para sa amin yan. Para isama na kita. Maganda pa para sa atin yan. Isama na kita.
Opo.
Maganda pa yun?
Ay, maganda po yan.
So, dapat hindi papalitan yan.
Ay, huwag palitan po ang judicial power dahil nga po, silensyo po ang U.S. Constitution on the judicial power. Silensyo po ang 35 and 70 Constitution. It's only in the 87 Constitution that we have an expanded meaning of judicial power. Ito po ay maganda po sa atin at sa hukuman ng Pilipinas.
Alam mo, merong mga questions galing sa Twitter.
Opo.
Tanong ata ni Madam Karen Davila ito
Opo.
Itong tanong niya. During his interview with former Commissioner Lagman, that means the interview conducted by Ms. Karen Davila.
Gas Lagman.
Commissioner Lagman, not Justice Lagman, Commissioner Lagman, I'm sorry.
I'm sorry. Gas Lagman ng COMELEC.
She could be a good chairperson of the COMELEC.
Opo.
During the interview of Madam Karen Davila with former Commissioner Lagman, according to her, Commissioner Lagman admitted that the filing of the case against GMA was rush. Binilisan daw ng COMELEC. Tanong na nito, do you agree? Gusto niyang marahil yung tanong, gusto niyang paribat. O yung sinabi ni Commissioner Lagman sa interview. I think that's what I understand from the question.
Justice Peralta, I think I will disagree. Dahil even before we decided on the case whether to file it or not, approve the recommendation of DOJ in COMELEC. Ito po ay pinag-aralan ko po. And then, nakita ko po yung recommendation. I've been in the practice of law for 26 years. At sa tingin ko naman po, after evaluation, ay pwede pong i-file. So, hindi po haphazard, but prior to that, I studied affidavits of the complainants against the respondents.
Madaling salita, you had sufficient time to read.
Yes, in so far as I'm concerned, sufficient po yung time na pag-aralan po.
Nandun pa si Commissioner Lagman nun?
Nandun po, siya po ay bumoto for the filing of the information.
For the filing,
Opo.
Oh, so he joined you, in other words.
He joined us. Kami po ay ilang bumoto po doon, kasama po ang aming chairman, Commissioner Yusuf, Commissioner Lagman, Commissioner Lim, and yours truly.
Ngayon, meron din isang tanong dito sa Twitter. Tinatanong niya, ano ba ang inyong masasabi tungkol sa kasalukuyang sistema ng party list? It is a general question.
Maganda pong katanungan yan, Justice Peralta, dahil ako po ang nagpasimuno sa COMELEC to fine-tune the provisions on party list. Very vague po ang provision ng Republic Act 7941. Sino bang kumakatawan ng marginalized? Ano po ang marginalized? Ano po ang underrepresented? Up to this very day, no amendments were introduced to Republic 7941. So we proposed a resolution. It's now resolution number 9366 to further fine-tune Republic Act 7941.
Where is that resolution?
We have a copy. It was promulgated already, Your Honor, please. As a matter of fact, you want to be a nominee of the marginalized? You prove by your track record, by speeches and documents that you are.
You know, the problem there is that you were citing the case of Mr. Mikey Arroyo, is it not?
Hindi lang po siya.
No, in particular, but you mentioned...
Opo.
Ang sinasabi mo ron, hindi siya pwedeng maging nominee ng party list ng gwardya dahil hindi siya gwardya. Ganun ba yun? Ayun bang
Dalawa
decision
po
mo?
ang punto ko po, nagalang-galang na hukom kung bakit po ako ay nag-disagree. Una-una po, at the time, we have a resolution, established track record. Were you an advocate of this security guard? Wala pong track record. Ang sinasabi lang po ay miyembro po siya within the 90-day period ng party list organization niya. Pangalawa, sa kaso po ng Bagong Bayani, OFW versus Comelec, ang sinasabi po ng ating Korte Suprema and Banat versus Comelec, the nominee should belong.
What?
Should belong. The word belong has been repeated a number of times. Should represent the marginalized. And the word belong, Your Honor, please, has been repeated a number of times in ang Bagong
Bayani. Kung sabi ng
versus
belongs, he should be a member.
Kaisa kanila.
But hindi
Isa
sinasabi na he should be impoverized.
Ang sabi po sa Banat, not necessarily wallow in poverty or
that's
destitution.
correct.
Not necessarily po.
No.
But ang mahalaga po, you belong to that sector. You advocate the interests of the sector based on a track record that you have to establish.
Okay, but yours was a dissenting opinion. Na-overrule ka ata doon eh.
Dissenting opinion po.
Anyway, that was brought, that's what I was saying. The same arguments were raised in a petition before the HRET because that congressman took his oath.
Opo.
So he was already proclaimed, so the aggrieved parties file a petition before the HRET using now your dissenting opinion as their arguments. No? Okay. Teka, nabanggit mo ata tungkol dun sa kaso sa Cavite, no? Yung para magkaliwanagan tayo ng konti.
Opo.
Unang-una ba, pabor ka ba sa PICOS machine?
Ako po ay pabor sa PICOS machine sa desisyon pong Kapalya versus Comelec, where the ponente is the Honorable Chair, and sustain the use of PICOS machines and the contract, the option to purchase. Justice Peralta, ako po ay sumasang-ayon.
Okay. Although that case now is under reconsideration. Subject to a motion for
But we are
reconsideration.
hopeful and...
Tinanong ko yan kasi, may nagsasabi kasi, kung meron protest, nasa rules natin kasi, ang unang titignan mo, yung picture image eh. Para maintindihan natin lahat, those who are listening from us. Kasi doon sa picture image, pag pinasok mo yung balota, nakikita yung, napipicturan yung ano yung balota eh. So makikita doon sa picture image kung sinong binoto.
Tama po.
Okay. So, when there is a protest, you do not rely on manual counting.
Tama po.
That is your position, hindi ho ba?
Totoo po.
But we assume that the picture image is intact. Hindi ho ba?
Ito po ay well-guarded.
We will not talk about that case, no? Kasi it's
Opo.
pending with you eh. Okay? Para maliwanagan lang ang publiko because you talk about picture image. Yung picture image, naka-record dyan?
Naka-record at nakatago po yung CF cards.
Sa CF cards?
Opo.
So, ang proseso, kung ito ang boto mo, ipapasok mo sa balota, may nagka-capture ng picture yan eh. Hindi ba?
Totoo po.
Then papasok yung balota, binilang na.
Tama po.
Binilang na eh. Nakalagay nga doon sa congratulations nga eh. Minsan, interpretation ng congratulations, nanalo ka na eh. But actually, congratulations because you voted properly. Yan ang ibig sabihin nun, hindi ba?
Tama po.
So kung may protesta at sinabi niyan talo siya, ang gagawin ng RTC or the HRT is to look for the CF cards, hindi ba?
Tama po.
Minsan may instances walang CF card eh. Are you aware of that, no?
Sa aming karanasan po, Justice Peralta, yung makaso po na-resolve namin.
Meron din, ano?
Mayroon po mga CF cards na ginagamit po namin. Kaya nga po, paglobas
But meron mga ibang CF, meron mga mga balot sa boxes na walang CF card. Meron, I think, I will not mention because it's pending before the HRET, where I sit as a member. Kaya ganun po ang sistema eh. Hindi ho ba? Kaya mas madali ngayon sa PICOS, mag-resolve ng cases.
Totoo po yan, Justice. As a matter of fact, maraming kasong winidraw po ng protestant.
Kaya kasi because of the 25% na
20% po.
Okay, you first proceed with the 25%. If there's no sufficient recovery, then there's no need to the remaining 75% protested presents. Hindi ba?
Tama po.
Ayun. Kaya mabilis.
Mabilis po.
So magandang PICOS machine.
Maganda po, Justice Peralta, kaya nga po ako po ay saludo sa inyo sa magandang desisyon niyo po
Naku.
sa kasong Kapalya
Paano ito?
versus Comelec, Gingona versus Comelec.
Saan po na iboboto ko nito? So, thank you very much. On that note, thank you very much.
Thank you
Maraming
very
salamat,
much.
Commissioner Rene. Okay, maraming salamat.
Salamat po.
The last one.
Your Honors, the last to be interviewed today is retired Judge Manuel de Jesus Ciainco of the Regional Trial Court, Branch 6, Malolos, Bulacan.
Okay. Judge, you may take your seat. Attorney Cayosa will now ask the questions.
Thank you, Mr. Chairman. Good afternoon, Judge Ciainco. What is the proper way to pronounce your surname, sir?
Ciainco po, sir.
Ciainco.
Ma'am.
Okay, Judge Ciainco. You indicated in your PDS that you are married. Is there any truth to the report that you sought an annulment of your marriage?
Oh, yes, Your Honor. There was an annulment proceeding which was finally decided by the Supreme Court, reversing the lower court's decision. And now, we're together again. My wife is here.
Thank you. You recently retired as an RTC judge, and after serving the court for 10 years, why did you decide to retire?
I was a judge for 6 years in the Municipal Trial Court of Malolos and 10 years and a half in the Regional Trial Court of Bulacan. I opted to take the benefit of early retirement at age 62. Well, honestly, because I stopped dreaming. I stopped dreaming of promotion to the Court of Appeals, to the Sandigan Bayan, after 6 attempts. And I felt I had done enough in the Regional Trial Court with regard to my docket, which was pegged at 640 cases when I came in June 2001. And when I left in December 2011, the docket of RTC Branch 6 Bulacan was 380. That means an average of, for the last 5 years I was there, I disposed of 700 cases out of 491 cases filed in that period of 5 years, as also indicated in the PDS.
Thank you, Judge. So why do you want to become Chief Justice?
In the first place, this was totally unexpected, ma'am, and I was surprised, completely surprised. In fact, I called up when I saw in the papers and heard on television my name being mentioned, I called up the JBC. Sabi ko, ano ba ito? Nakuryente ba kayo? Totoo ba to? Kuryente is the word used by media for false information. Yes, it's true, sabi nila. And we have here a copy of the recommendation. We will send it to you via email. And then again, a group of former colleagues from my seminary days made a second endorsement. So I am dreaming again. of entering the judiciary at a time when, after the impeachment proceedings and with the high expectations of the people of a reformed judiciary, I'm dreaming again.
Thank you, Judge. That was my last question. Good luck. Justice Peralta, thank you.
Attorney Mejia.
Thank you, Justice Peralta. Good afternoon, Judge Sianco. Judge, having been an MTC and an RTC judge for a significant period of time, if you are to articulate the common sentiments of lower court judges, what would those sentiments be?
Well, Your Honors, the RTC and MTC judges, we have taken offense and we take strong exception to the stereotype and often used term of hoodlums in robes. We know, for example, in the Regional Trial Court of Bulacan, that most of the judges there are straight, honest, efficient. So we take offense at this or stereotype of hoodlums in robes. Although we are aware that there are problems in the lower courts, the docket is sometimes unmanageable. The average time in the trial and disposition of cases lasts up to 5, 6, 7 years. The sentiment of the lower court judges is parang by the way, in the seminars on personal security, which are being conducted by the Supreme Court, PhilJA, NBI, the first session is about statistics. Judge Ralph Lee gives statistics on the past 10 years. There have been 23 judges killed. The last one was Judge Arles of Bacolod Regional Trial Court. We know him to be honest and to be straight and to be efficient. So we are at the forefront, we are at the front lines of the judiciary, and we receive the brunt of threats, sometimes efforts at bribery, but we hold our ground. So the sentiment of lower court judges is, especially those who receive administrative cases left and right. I myself was a recipient of 7 administrative cases when I was in the municipal trial court for 6 years, all dismissed. The sentiment of the lower court judges is that it's somewhat unfair. There is not enough system of rewards and lower court judges to aspire for higher position. That's it.
So, what significant achievement, if any, can you consider that has marked your judgeship?
Well, Your Honors, it is the fact that I have been consistent, regular in the performance of duty. As I mentioned, my docket was 640, and when I left, it was in the regional trial court, it was 380. That in itself may not be an extraordinary achievement, but I would like always to think that I've done my best, and like what I have been quoting in my blog sites and pieces in the site of XBD Philippines at multiply.com, the blog site where Father Jerry Orbos, Father Bel San Luis are doing their Sunday sermons. 2 Timothy chapter 4, verse 6 to 8. I have fought a good fight. I have run the race to the finish line. I have kept the faith. I have kept the faith of what I received, the training for 11 years in the seminary, the moral integrity founded on a deep spiritual formation which I received and which cannot be developed outright in the 4 or 5 years of the law school. That's it, Your Honor.
I understand, Judge, that you previously applied for the Sandigan Bayan and the Court of Appeals. Were you shortlisted in those?
No, I was not.
If you were not considered for those positions, what makes you think now that you will be considered for the Chief Justice position?
Well, the fact that I'm here, out of 70 in the long list, in the original list, there are now only 22. And I heard 2 have been disqualified so 20. It's an honor for me to be included in the 20 long list of candidates for the position of Chief Justice.
Thank you, Judge. That's my final question. Good luck po. Thank you,
sir.
Justice Peralta.
Justice Lagman, please.
Thank you very much, Mr. Chair. I have read the statement, which is supposed to be your opening statement, which is given to us. This the one? A 3-page statement.
That is from the XPD Philippines, ma'am?
This is the paper which you submitted to the IBC.
Oh.
Yes. I know Judge Shenko very well because we worked together when I was still an RTC judge in Bulacan. And with my personal knowledge of his character, he was a seminarian before, is it not?
Yes, Your Honor.
And I know him very well. I find no reason to further question him. And the fact that we have interviewed him several times when he was applying for the Court of Appeals and the Sandigan Bayan. Okay.
Thank you,
On
Justice.
that note, I don't have any more questions for Judge Shenko. Thank you.
Justice Hermosissima, sir.
Good afternoon, Judge.
Good afternoon, sir.
Well, we have interviewed Judge Yanko quite extensively before when he applied for Sandigan Bayan and the Court of Appeals. So we keep our record straight, and so thank you very much.
Thank you, Your Honor.
Secretary Mosngi.
I have no questions for the aspirant. Thank you, Your Honor.
Okay, just few questions, Judge. When did you retire, Judge?
I retired, Your Honor, in December, as of December 31, 2011.
You were, how old were you? 62?
62 years,
So
Your
it's
Honor.
an optional retirement.
Optional retirement.
After probably passage of the new law granting a shorter period of time in order to be entitled to the full benefits.
Yes, Your Honor.
You waited for that probably.
Yes, Your Honor.
The other reason is that by retiring from the RTC, you can now apply to the position of Chief Justice because you are now considered as an outsider.
Well,
Is my impression correct?
I was not really thinking of that, sir.
Because
When I retired, I just wanted to enjoy the fruits of my labor, which, by the way, I have not.
Why?
It's been 7 months since my date of retirement, and my papers are still being processed. No benefits yet. I'm now living the vow of poverty which I took when I was a novice of the missionaries of the Divine Word.
but probably God is telling you to go back to the seminary.
Well, when I received the information from JBC, I consulted my former classmate and rector who is now the parish priest of Kamuning Sacred Heart Parish, Father Linus Nicasio, and he said, how would you know if it's God's will for you, if you will not try? So I do not want to disappoint those people, my former colleagues from my seminary days.
Yeah, because I remember Chief Justice Fernan. No? I think he had a judge at that time, an RTC judge at that time, who retired and then became a priest. Yeah, there was one.
I can now no longer become a priest and go back to my first love because my second love is here.
Oh, I'm sorry.
My wife is here.
I'm sorry. I'm sorry. So my other question is, do you have an edge against the other over the other applicants? Do you have an edge over the other applicants, whether insider or outsider, Judge?
I would like to believe, Your Honor, that my background, my spiritual foundations, my being or having been a judge of a lower court gives me, well, not really an edge or an advantage, but a certain viewpoint of having a heart. But by the way, it's not only moral integrity, probity, competence, and independence that should be the characteristics of the next Chief Justice. He should also have a heart that bleeds with the miseries of our people and rejoices with their victories and their struggle for justice.
Mm-hmm.
I do believe I have that from my experience as a lower court judge.
Okay. On that note, I will not anymore ask more questions. Okay. Your excuse.
Thank you.
Judge. Now we will start at 9 o'clock tomorrow with 2 nominees in the morning and 2 nominees in the afternoon. With that, session today is adjourned.
Si Richard. Si Richard, nakakalimutan ano yung bell eh.
Sir, ang galing-galing nyo, ang lalalim nyo managalo.
Talaga?
Talaga, binalang